whenever you are ready to get us going. I think the committee's ready. It looks like we are live now. Good morning, everyone. Welcome to the Joint Standing Committee on the Judiciary. We have two public hearings today, one in the morning on LD 1310. We'll start with that, and then we'll resume this afternoon with our public hearing on LD 1950. And we will start, as we always do, with committee introductions. And I'm just going to call on committee members as I see you on the screen. If you could please introduce yourselves. Representative Thorne, we'll start with you today.
Thank you, Madam Chair. Good morning from Carmel. My name is Jim Thorne. I represent House District 103, which is Carmel, Herman, and a portion of Edna up in beautiful Penobscot County.
Representative Sheehan.
Thank you, Madam Chair, and morning, everyone. I'm Erin Sheehan, and I represent Biddeford's House District 12.
Representative Newell.
Thank you, Madam Chair. Good morning, everyone. My name is Rena Newell, and I represent the Passamaquoddy tribe.
Representative Poirier.
Thank you, Madam Chair. I am Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Representative Reckitt.
Morning. My name is Lois Reckitt, and I represent District 31, which is the ocean end of South Portland.
Representative Babbage.
Yes, good morning. My name is Christopher Babbage. The sad part of my story earlier is that I had studied French. So I represent House District 8, which is most of the town of Kennebunk.
And
if I could apologize, I forgot to say that I'm going to be in and out today. I've got another committee exactly the same time period at the same. Anyway, I'll be in and out. Thank you.
thank you for letting us know. Representative Moriarty.
Thank you, Madam Chair. Good morning, all. I am Steve Moriarty, coming to you from Cumberland, where the rain has stopped. My district consists of Cumberland and part of Gray. It's number 45.
And Co-Chair Harnett.
Can you hear me? I just had to switch devices. Am I on?
You
Yes.
are.
Okay, thank you. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner, where I reside.
Thank you. Representative Libby.
Thank you, Madam Chair. My name is Laurel Libby, and I represent District 64, which is Auburn and part of Auburn and all of Minot.
And I caught every committee member? The squares were moving around, and so I might have missed someone. Okay, looks like we're all set. And we're joined this morning by our OPA analyst, Peggy Reinsch, and also by our committee clerk, Susan Panett. And I am Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough.
Okay.
And so we are ready to begin our work this morning. And so I'll open the work session, the public hearing on LD 1310.
Get it on here.
The sponsor is unable to be with us this morning. And so Representative Harnett has stepped in and will be presenting the bill. But before you begin, Representative Harnett, let's give Representative Evangelos a moment to introduce himself as well.
Thank you, Senator Carney. Jeffrey Evangelos, House District 91. I reside in Friendship. Good morning.
Good morning. Thank you. And with that, the floor is yours, Representative Harnett.
Thank you very much, Chair Carney. Good morning, all. Senator Carney, honorable colleagues of the Joint Standing Committee on Judiciary. I am presenting testimony on behalf of Representative Rachel Talbot Ross today. Representative Talbot Ross represents House District 40 in Portland and serves as an assistant House Majority Leader. She thanks you for the opportunity to present LD 1310, an act regarding criminal records. Representative Talbot Ross sends her heartfelt apologies that she cannot be with us today due to a family emergency. This bill was originally a concept draft So I wish to begin by noting that I will be speaking to the proposed amendment today, which is attached to her testimony and has been distributed to committee members. The proposal before you today is the result of a long and deliberative process that has engaged and incorporated input from a wide range of stakeholders. As members of the committee are aware, the Criminal Records Review Committee, established by the legislature last year, formalized ongoing discussions around complex matters of sealing or otherwise addressing criminal records. Our shared goal has been to identify ways to ensure those who have been convicted of crimes and served their sentences are able to return to their communities without their convictions holding them back from leading successful, fulfilling lives, while also protecting and advancing public safety. LD 1310 is a critical step towards fulfilling that goal. The proposal is based on Public Law 2015, Chapter 354, which provided a process for motions to seal criminal history that was used beginning in 2017. The law contained a sunset provision and was automatically repealed on October 1st, 2019. Before the sunset, the law was successfully implemented without issue, giving dozens of Mainers who utilized the process a true second chance. The committee examined Public Law 2015, Chapter 354, and how the legislature could build upon its success moving forward. The proposal before you today strikes a balance between the interest of public safety and mitigating the harm that publicly available criminal records are known to cause individuals who have already served their sentences. LD 1310 uses the same proven process to seal criminal records for eligible convictions that was used in the public law that sunsetted, and it expands the eligibility criteria. A person with an eligible conviction would be able to file a motion to seal the record if at least 4 years has passed since they fully satisfied their sentencing requirements and that individual has not committed a crime in the meantime. A new conviction would extinguish the individual's eligibility for sealing. Under this proposal, all former Class D and Class E crimes are eligible, with certain exceptions based on input from stakeholders. These exceptions include sexual assault, sexual exploitation of minors, sex trafficking, stalking, domestic violence, violation of a protective order, and cruelty to animals. If the court determines all requirements have been met, the court would be able to seal the criminal history record information. Notice would be provided to the person filing the motion, the prosecutor's office that had prosecuted the individual, and the State Bureau of Identification. Once sealed, the criminal history record information would be confidential. However, an exception is included to allow victims of the crime to access the sealed records. Members of the committee may recall LD 1459 from last session, a similar message that did not move forward to allow for a Criminal Records Review Committee to do its work. LD 1310 is similar to that measure, but incorporates the feedback and suggestions discussed by the entire Criminal Records Review Committee. The majority of that committee supported bringing an updated version forward for public hearing and for your consideration, which I am pleased to do today. I'm enormously grateful to the array of stakeholder groups who have contributed to this process. These include victim advocates, formerly incarcerated Mainers, representatives of the judicial system, law enforcement, legislators, and numerous others, a number of whom are here today to speak to their perspectives in more detail. I believe that the testimony you will hear from them will demonstrate that this is a thoughtful, balanced proposal that deserves our support. Representative Talbot Ross thanks you for your consideration, and she will be available to answer questions at the work session, but is fully aware that you will hear from people familiar with this topic who will be able to address questions today. Thank you.
Thank you very much, Representative Harnett. And before we turn to the committee to see if anybody has questions, I wanted to give Senator Sanborn an opportunity to introduce herself.
Thank you, Senator Carney. I'm sorry I'm late. My name is Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook, and that's Calypso.
Thank you. Committee members, are there questions for Representative Harnett regarding LD 1310? Representative Moriarty, go ahead.
Thank you, Madam Chair. Representative Harnett, I don't mean to put you in a difficult position because I realize you're filling in for the Assistant Majority Leader. But I note that the report of the Criminal Records Review Committee from December of 21 actually contained only 3 recommendations, and record sealing wasn't one of them. So if you know, where did this particular bill come from? It doesn't appear to have been endorsed by the Records Review Committee, and in fact, the input we received from the Maine Freedom of Information Coalition made that same point. They had not covered the topic. So I wonder if you can shed any light on that.
I don't think I will be able to shed as much light as you would like, Representative Moriarty. I was on the Records Review Committee and know that this was a topic that was discussed in detail. And it was always the goal of the committee to, at least the majority of the committee, to advance this bill as a continuation of the public law from 2015 that had sunsetted, with the attempt to make some minor changes to that to incorporate the concerns raised during the committee process. I'm hopeful that individuals you will hear from later this morning might be able to provide more detail on that.
Okay, thank you. Madam Chair, I'll defer for the moment. I do have a number of other questions to ask.
Are they questions for Representative Harnett or for others?
Well, at least at the outset for Representative Harnett.
Let me just check and see if there are any committee members with questions. Not seeing other questions. Go ahead with your next question, Representative.
Okay, thank you. As I read the bill, it applies to eligible criminal convictions, which basically are Class D or E crimes, and perhaps some others as well. And records of criminal convictions that fall within the eligibility standard may be sealed if the appropriate procedures are followed. And so all of this makes good sense and is straightforward from my point of view. But then we get to page 6 of the bill, where it changes its focus from Title 15 to Title 16. And you'll see there's on page 6, there appears section 703, subsection 2 of Title 16. And it, in my view, redefines confidential criminal history information to include cases which basically were not prosecuted for some reason, or in which there was a delay, or in which charges were dismissed, or cases in which someone was acquitted. As I read this extract from Title 16, confidential criminal history record information does not include convictions, which I think is totally inconsistent with the first part of the bill, which is specifically designed to address convictions. Any insight on that?
And I again need to apologize, Representative Moriarty. I actually don't have the amendment in front of me. I have the concept draft.
Okay.
I had some logistical issues about changing locations today.
Okay.
So I would ask you to defer that to others or bring it back at the work session. I apologize.
I'd be glad to. I just want to make the point that I think the bill is internally inconsistent, and it's got to be a reason why, but I'm not sure what that is.
Okay, thank you.
And I may be able to help out with that, Representative Moriarty. The language on page 6 that's in Title 16, that's the existing definition of the criminal history record information that is confidential. And then if you flip over to page 7, the underlined the new paragraph, which is paragraph M, which is underlined, that's the new language that's being added in this bill. And it just simply incorporates a reference to the section 1 of this bill into that statute in Title 16. So that's the only new language in Title 16 is that reference on page 7 of the bill, the underlined paragraph M. Does that help?
Yes, it helps, but I think the whole statutory construct is a little confusing. In other words, why would we retain all of this language from Title 16 with a new sort of cross-reference subparagraph at the end? I find the two read together are confusing and inconsistent. I appreciate the fact there is a direct, you pointed out to me, it's a direct cross-reference, but
yeah,
they don't jive together very well.
Yeah, and I think, and maybe we'll hear from others or we can ask our analysts, but I think 16 is much broader. So if you look at paragraph B, for example, in section 2, that's talking about information regarding cases that haven't been prosecuted. So if there's information about cases that never lead to a conviction can be considered confidential criminal history record information.
Okay.
So, and I think maybe this is something we can dive deeper into when we have our work session on this legislation.
Okay, alrighty, thank you.
Seems like a good subject for a work session.
Yes, yeah.
Okay, committee members, any other questions for our bill sponsor? Excuse me, for Representative Harnett. Not seeing any. Thank you very much, Representative Harnett, for stepping in to present this legislation to us.
Thank you, Senator Carney.
And now we will hear from members of the public who wish to testify in favor of this legislation. And if you are here to speak in favor of it, please raise your electronic hand and keep it raised until I have brought you over from the attendee part of the meeting to provide your testimony. And I see the first raised hand is from Michael Kevada, and I will have him join us momentarily. Welcome to the Joint Standing Committee on the Judiciary, Michael Kevada. You can proceed when you're ready. And just to let everybody know, it is the custom of this committee to run a 3-minute clock and then to turn to questions.
Thank you very much, Senator Carney, Representative Harnett, and distinguished members of this committee. My name is Michael Kevada, and I'm Policy Counsel for the ACLU of Maine. On behalf of our members, we urge you to support this bill because it would help free Mainers from the debilitating unintended consequences of certain criminal records. I think it bears repeating that this is how criminal law is supposed to work. The legislature decides that something's a crime, then it designates consequences for committing that crime. These consequences are designed to be proportional to the crime. They can include a prison sentence, rehabilitation or mental health services, community service, supervised release, and still more. Unfortunately, for as long as there have been criminal laws, but exponentially more in the digital age, a criminal record has prevented people from continuing their education, getting housing, a professional license, credit, investments, and other features of a stable, dignified life. In short, a criminal record has prevented millions of people across the country and thousands across Maine from moving on with their lives, pushing them into second-class status even after they have completed their sentences. Now, the legislature and this committee was aware of this problem 2 sessions ago when you supported LD 764 and last session when you supported LD 2086. The first bill established the Criminal Records Review Committee, a bipartisan group that included lawmakers, prosecutors, law enforcement, and still more stakeholders. The second bill extended the life of that group. As Representative Harnett said, the first group reported out a piece of legislation that would extend the life and scope of the law that sunsetted on October 1st of 2019. The last iteration of the Criminal Records Review Committee, to Representative Moriarty's great question, actually did recommend that this bill get a public hearing. That was recommendation number 3, and I have the Criminal Records Review Committee's report right here. And the bottom of page 15 to page 16 is where that recommendation is. And a majority of the members of the Criminal Records Review Committee, a supermajority actually, recommended that this bill get a public hearing. This bill, if enacted, will allow people who've been convicted of some but not all misdemeanors, that's class D and E crimes, to get their record sealed if they satisfy certain requirements. 4 years have to pass since they've completed the designated punishment for the crime. They have to have no other convictions in Maine or elsewhere. They must have no pending criminal charges in Maine or elsewhere. They must not commit any crimes after their records are sealed. If they do, then their sealed crime is unsealed. The list of crimes for which sealing would not be allowed under this law is long. I won't go through it. It's in my testimony. Representative Harnett mentioned some, but not all, of this list of crimes. I would like to conclude by briefly addressing Representative Moriarty's great question about the seeming internal inconsistency in the bill. So I think that Senator Carney was absolutely correct. The only thing that the reference to the confidential criminal history record information, or I think some practitioners call it CHIRA. The only thing that reference does is it folds the bill into the Maine Revised Statutes way of sealing criminal records, and that's the Confidential Criminal History Record Information Act. That's how Maine currently designates which crimes are sealable and which crimes are not. And what this bill would do is expand that regime to include misdemeanors. And so the reference at the bottom of page, or in the middle of page 7, part M, the underlined part, that directly links this bill, the law that this bill would create, to the Confidential Criminal History Record Information Act. If that doesn't happen, then there's no way to indicate to the State Bureau of Identification, to the judiciary, and to the rest of the system which criminal records should be sealed and which not sealed. Thank you for your time and attention. I'm happy to try to answer questions, and we urge you to vote ought to pass.
Thank you very much. And I see that there are some committee questions. Representative Moriarty, go ahead.
Thank you, Madam Chair. Thanks, Mr. Capita, for drawing my attention to recommendation number 3, which I had reviewed. What may have led me astray is that recommendation number 3 refers repeatedly to LD 1459. And according to my research, which is always subject to scrutiny, on June 8 of last year, the committee reported ought not to pass. And on June 9 last year, it was placed in the legislative files and became dead, so to speak. I do not or did not understand that 1459 was still before the 130th. And so I didn't understand why the committee repeatedly referred to what I thought to be a dead bill?
I would like to answer that, Representative Moriarty, because I think it has to do with internal committee decisions that were made. We were facing at the end of the session many bills related to criminal records. We had a limited number of carryovers, and we knew that we had the criminal records review bill that was going to go into effect. And so we knew that there was going to be additional work related to all issues pertaining to criminal records. And that's why there were a number of bills that we voted ought not to pass on, knowing that there was a potential for them to come up this session through another vehicle. It was simply because we had, I think, we were permitted 17 carryovers, and there were just a lot of bills that we couldn't take up last session because we wanted to await the work that was done by the Criminal Records Review Committee. So it was a process decision and not a decision on the merits.
So am I correct, Madam Chair, that 1459 was not carried over?
That's correct. There were a number, I can't remember. I don't know if Representative Barnett remembers, but there were maybe half a dozen bills that were kind of in the same posture that we were not able to carry over. And so we ought not to pass them.
Okay, thank you. I don't mean to split hairs, but the committee's third recommendation is that judiciary hold a public hearing on LD 1459. And so I did not read that it confused me because the references to it was a non-existent bill.
Understood. Yeah, Representative Harnett, and then we'll return to Michael Kebada.
I think, first of all, Senator Carney, you explained the situation correctly. The committee knew that this topic was going to be covered or discussed by the Criminal Records Review Committee, and therefore that's why LD 1459 was voted ought not to pass. It was to allow the committee more time. I think the reference to LD 1459 in the report is probably in error, and that the public hearing would be on the bill that brought that work forward, and that's what we see in LD 1310.
Okay, thank you.
Michael Kebada, did you have something to contribute in response to that question?
I did, yeah. I actually, I completely understand where you're coming from, Representative Moriarty. Why are we resuscitating a dead bill? This is procedurally improper. But I think that the report of the Criminal Records Review Committee was mindful of this issue. And if you carefully read recommendation number 3, it doesn't say hold a hearing on that bill. It says hold a hearing on the proposals for petition-based records sealing as proposed by LD 1459. And then later in the proposal, it says the language of LD 1459. It says, again, the language of LD 1459. And then the last reference to 1459 doesn't say hold a hearing on 1459. It says hold a hearing on the process as proposed in LD 1459. So there is mindfulness about the fact that that bill is not getting a public hearing. That bill never got a public hearing. It's the contents of that bill that are getting a public hearing. And the contents of that bill were arrived at through a painstaking process that involved lots of very diverse stakeholders that included everyone from prosecutors and law enforcement to advocates for survivors of sexual violence and domestic violence. And so, I don't think the Criminal Records Review Committee and the committee analysts who drafted this great report were trying to get around procedural rules. They were instead trying to preserve the work of a very large group of diverse stakeholders who have an interest in this issue. I hope that answers your question. I'm happy to.
It does, Mr. Kebada. Thanks for that explanation. At the risk of sounding like I'm quibbling, in retrospect, it would have been clearer if the committee in its third recommendation had recommended new legislation carrying forward the principles of former LD 1459, because it reads as though, to me, as though it's still live and on the front burner. But that's
and there is an answer to that question too. That actually issue did come up, believe it or not. And the answer to that question is, it wasn't clear to the members of the Criminal Records Review Committee which piece of legislation would serve as a vehicle for the contents of LD 1459. And so the Criminal Records Review Committee wasn't certain whether their recommendation would get captured by the suggestion to report out new legislation, because that was one possible path. Another possible path is the one we're on now, which is LD 1310 serves as the vehicle for the contents of the dead LD 1459. And so your points are all excellent, well taken, but there are reasons why the recommendation doesn't explicitly say report out new legislation. And I can tell some people are falling asleep, so I'll stop talking.
Thank you.
Thank you. I see we have another question. Representative Babbage, go ahead.
Thank you. If they were starting to fall asleep, I thought I'd sing the final lullaby here. Don't nod, Representative Evangelos. So anyway, Mr. Cabetta, I have two questions, if that's permitted. One is about the ACLU, and the other is about the law in this case. Regarding the ACLU, and I respect your testimony every time. You can probably tell by results, but the ACLU's charge is to defend individual liberty, as I see it. And I just wanted to ask, is it beyond the scope for you to defend such things as transparency or freedom of the press?
No, not at all. Individual liberty is the thing that we're most famous for defending. But we have a much vaster set of constitutional rights that we defend. And one of those is the one that you mentioned, freedom of access for the press. Now, when we do that, we have to balance the libertarian interests and the constitutional rights that are implicated on the other side of the equation. And that's the balance that this bill asks us to strike. And we think that this bill does strike that balance.
Thank you, because obviously that's our task as well. If I may, Madam Chair, the second one has to do with ongoing punishment for an original offense. And I just wondered, what's happening with the law with regard to this kind of issue? And in other words, because it helps to understand what this bill is addressing. I wondered if, scarlet letter judgments and things of that sort, but the ongoing detriment that in employment and in housing and all of those things that could happen from this, is that challengeable under, I don't know, double jeopardy provisions? Or, how have the courts looked at this? What direction are we going as a society or in Maine here regarding this?
That's a really great question, Representative Babbage. It's not exactly challengeable under principles of double jeopardy, because it's not the state that's inflicting the second round of punishment. It's the rest of the society. And as far as where are we moving as a state and as a society, there's actually Republican leadership at the national level that's been ahead of the curve on this issue over the last decade. The Trump administration signed legislation into law that gives thousands of people who've been convicted of federal crimes a second chance. And I think there's a growing realization across the political spectrum that this violates our core precepts about fairness and justice. And this does what you refer to as impose a scarlet letter on people and punish them long after their statutorily designated punishment has expired. And so there is movement in Maine and across the country at the federal level and in almost every state in the direction of sealing records and giving people a true second chance.
Thank you for the response, and thank you, Madam Chair.
You're welcome. Committee members, any additional questions? I had a question for you, Michael Kebeda. Is there, I think in the introduction, Representative Harnett described the prior measure that was in effect. Can you tell us how many years it was in effect?
I think just a few years. I don't have the number off the top of my head, but I'm happy to get that to you by the work session. And I'll also mention that it takes money to take advantage of this law. And that's one of its flaws, unfortunately. And so, to hire someone to file this application for you is not cheap, it's not free, it's not automatic sealing. So this is not the gold standard, but this is a good start.
Thank you. And I have another question for you, but I see that other committee members do as well. So I will defer to them. And if they don't ask my question, I'll circle back to you. Representative Evangelos, go ahead.
Thank you, Madam Chair. Good morning, Michael.
Good morning.
Michael, one of the things that's always bothered me since we legalized marijuana and all these shops are going up like the Wild West. A lot of people, you spoke eloquently about how people weren't able to find jobs and had their lives ruined because of convictions. Can you, for the work session, if you can't answer it briefly now, have we dealt with that in terms of expunging all marijuana-related convictions? Seems a little ironic that people would still be suffering this life penalty when everybody, including the state, is in that business right now. Do you have anything for me on that?
I can try and get you statistics about that by the work session, but I think you're right that people currently are making money legally by doing something that very recently was a crime that others were sent to prison for and continue to suffer from. And so that is happening in Maine and elsewhere. And I did actually get a chance to quickly look at the sunsetted law, and I can answer your question, Senator Carney. 4 years. The sunsetted law went into effect October 15th of 2015, and then sunsetted in October of 2019.
And also the state's collecting tax revenue off of marijuana sales, which
yes,
adds insult to the injury. So I look forward to seeing what you have in the work session. Thanks a lot.
Representative Moriarty.
Thank you, Madam Chair. I'm not sure who's waiting in the attendee room, and the question may more properly go to somebody else, but this is it. I'm looking at the appeal provisions of LD 1310, and if a convicted person files a motion for sealing and that is granted, the state can appeal to the Maine Supreme Court as a matter of right. If the person filing the motion for sealing has that motion denied, that person can only appeal to the court within the court's discretion. The court does not have to take the appeal and can simply say, nope, we're not interested, we're not taking your case. What accounts for, what is the rationale, I wonder, between these two different standards of acceptance of an appeal?
I don't have an easy answer to that question, but I think it's an excellent one. I'll defer to people who testify after me, and if they can't answer the question, I'll get you an answer in the next few days.
Okay, thank you.
Thank you for the question, and thank you for doing some research on that, Mr. Kebeda. Committee members, any additional questions? Not seeing any. Michael Cabot, I was wondering if you could shed some light for us on the fact that I think it's two of the provisions have a 20-year time limit. Two of the exceptions have a 20-year time frame. Most of the exceptions do not. And if you could help us understand why the 20 years was a limit for some of the exceptions and not for others.
I think that might be a better question for the Maine Coalition to End Domestic Violence, who will be testifying after me. But I think it might have to do with the state's automatic schedule of destroying criminal records. But those exceptions came from groups like MCEDV and Mikasa, and I think they'll be testifying after me.
Yes, they will be. Thank you. We've asked you a lot of tough questions today. We appreciate your willingness to answer them or to find answers for us. One last opportunity for committee members to ask questions. Not see. Oh, let's see. I don't know. Representative Libby, did you have a question? Yes. Okay, go ahead with your question.
Thank you. It's actually not for Mr. Kebeda, though. I don't want to forget it, and it's a note for Peggy. Last session, we had a document that outlined the crimes that fall into the D and E categories, and I can't find it anywhere, but it would be very helpful to have that added to the committee information on this bill, if we could get that again.
Thank you for that question. Okay, we're going to hear from Andrea Mancuso, who will join us in a moment. And Michael, I'm going to move you back. Andrea Mancuso, thank you so much for joining us today. You can begin your testimony whenever you're ready.
Good morning. Thank you. Good morning, Senator Carney, Representative Harnett, distinguished members of the committee. My name is Andrea Mancuso. I'm the Public Policy Director for the Maine Coalition to End Domestic Violence, and I'm here today to express our network's support for LD 1310. This bill is an important step to implementing public policy that can work to reduce both poverty and violence in our communities. You often hear from us that more needs to be done to hold those who choose abuse and violence accountable for the harm they've caused. This remains true. We also believe that criminal records can be an important component of community accountability, particularly where they inform the decisions made in our civil and criminal justice systems that have an impact on long-term safety and well-being of survivors and their children. What criminal records should not be used for is to shame someone for past criminal behavior in a way that it shackles them to a permanent lower socioeconomic class. In our written testimony, I've provided some information on community risk factors for violence and a brief explanation of why we think criminal records attends to lowering some of these community risk factors for violence. I've also provided some information that speaks to the reality that many survivors do not separate from the person who's been abusing them, and how impacting economic viability with conviction records publicly available has an impact on the whole family. And also a note that the last decade has seen Maine incarcerating substantially increased number of women, often for crimes that can be directly tied back to the abuse they've experienced at the hands of their partner. What I'd like to spend the remaining amount of my time on this morning is talking about the exceptions to eligible crimes that you see in LD 1310, and giving some context for our evolution on that. MCDV and our network of domestic violence resource centers would encourage you to carefully examine the list that you currently see in 1310 and consider whether those exceptions continue to be necessary. By way of context, when Representative Talbot Ross invited us into a conversation amongst community partners hoping to create some of these options for sealing of criminal records in 2019. Our network had not yet had an opportunity to really thoughtfully engage in the necessary conversations that we needed to with providers and advocates, many of whom are trauma survivors themselves, or our colleagues nationally on this topic. And in an effort to participate in the broad consensus that was reached by the initial group of folks that were working on this issue, we asked for and working group partners agreed to the list of exemptions that you see reflected there. This list accounts for the entire universe of crimes that would result from or be representative of domestic abuse and violence. It really is our request to say, oh, please just take our crimes and put it over here for now. And in doing that, we committed to facilitating conversations within our network. And we've had an opportunity to do that over the last 2 years. We've also had an opportunity to consult with our colleagues in other states who have implemented statutes that allow for this type of sealing, or who are similarly engaged in these conversations in their own state. And from this work, our network would support the sealing of all misdemeanor crimes, provided that the sealing proposal continues as LD 1310 does, to require the 4 years have been spent, and to ensure that both criminal justice agencies and victims of crime retain unrestricted access to these conviction records. We believe that that strikes a fair balance between the need for information relevant to ensuring safety on the one hand, and the need to better address the detrimental harms that prolonged public access to these records can create on the other. So regardless of what you choose to do with the exemptions, we felt like it was important to sort of, because most of them came from us, to share with you sort of the evolution of our perspective on that. So thank you for the opportunity to be heard today, and I'm happy to answer any questions that might be helpful for us to speak to.
Thank you very much. I'm going to start with a question because the timer was going off and I didn't hear the second half of your discussion of where your group has kind of the point you've come to with regard to the exemptions and Class E exceptions. Could you just restate that, please?
We would support the committee removing all of the exemptions and creating a process that seals all misdemeanor crimes after 4 years have passed, provided that 4 years must have passed since the completion of all components of the sentence, importantly, including the payment of court-ordered restitution, and that the proposal continues to ensure that criminal justice agencies and crime victims retain unrestricted access to these records, which LD 1310 does. And that was an important component for our network to continue to remain in the bill.
Thank you very much for restating that. Appreciate it. Committee members, are there questions for Andrea Mancuso? I don't see any questions for you. Thank you very much for being here this afternoon or this morning. Appreciate your testimony. And I'll turn once again to those who are in the attendee portion of the meeting and ask if you are here to speak in support of LD 1310, please raise your electronic hand and keep it raised. I'm not seeing anyone else. If you are in the attendee portion of the meeting and you're here to speak in opposition to LD 1310, please raise your hand and keep it raised. And, Judith Meyer is here to speak in opposition, so she'll be joining us in just a moment. Judith Meyer, welcome to the Joint Standing Committee on the Judiciary. You can begin your testimony when you're ready.
Thank you, Senator Carney. Good morning, Representative Harnett and members of Joint Standing Committee on judiciary. I'm Judy Meyer, and I'm representing the Maine Freedom of Information Coalition this morning. And a lot of what my testimony contains has already been discussed, but the bill before you is a rendition of 1459. It is, and during the Criminal Records Review Committee work, we did discuss, would it just be simpler to take 1459 and drop it into 1310, give it a fresh title, give it fresh language, take away all this kind of murky, it was not brought forward, but the consensus of the committee, and it actually might have been a vote of the committee, was not to do that. We purposely did not do that. We purposely decided to bring 1459 forward to get the public hearing it did not get last year. Unfortunately, I didn't see the language of 1310 until 1 o'clock yesterday when it was sent out to committee members. But a quick look at that last night indicates the new version settles on sealing certain criminal convictions. Our committee talked about sealing, expungement, a host of 4 or 5 other options to make records confidential, and we never settled on sealing. So I don't know where along the path of this process the option to seal was settled on, but it was not at the committee level, which I think is important because we had those discussions and we could not agree on a consensus language. And the bill, to my understanding, includes many of the suggestions discussed by the Criminal Records Review Committee. And to my reading, there are a couple of suggestions incorporated, including removing 2 paragraphs that the Maine Press Association objected to that would criminalize releasing criminal history information. But there were dozens of other recommendations that are not included, that were not even discussed at the committee level, including the cost factor here. And MFOIC has a grave concern about the inequity, what we see as a horrible inequity here created with the cost of having defendants have to pay for their own lawyers to seal their records. When Title 15 had the pilot program for the 4-year stretch, in 2017, 12 defendants filed motions to seal, 8 were granted. In 2018, 13 defendants. Now we're talking about the universe of all convictions, 13 filed for seal, 6 were granted. In 2019, 23 filed, 11 were granted. And in 2020, 7 were filed and only 1 was granted. And we asked why, and the consensus feeling by the judiciary and by, I think, the Prosecutors Association was that defense attorneys didn't tell their clients it was an option. And if the clients knew it was an option, they couldn't afford it. So this offer that was made for people who have criminal convictions in Maine for a 4-year stretch was barely scratched because of the inability to afford doing that. To go back to that process, knowing we have the statistics that tell us that, knowing that, I think is not the way to go. We need a simpler system. Many states have already adopted simpler systems, petitions. There are no cost or low cost ways to do this. And those recommendations are not included in this bill. We also looked at the list of Class D and E crimes, but it was by email at the committee level. We never discussed what those crimes are. This bill would seal things like assault, OUI, forgery, tax evasion, and a host of drug crimes, including marijuana. The crimes are not created equal, as Justice Alexander pointed out in his recommendations, nor were the circumstances of conviction, and yet this bill treats them all the same.
Judy Meyer, I'm sorry to interrupt you, but the 3 minutes has passed, and I expect that committee members will have questions.
Of course, thank you very much.
Yeah, thank you. Committee members, are there questions for Judy Meyer? Representative Moriarty, go ahead.
Thank you, Madam Chair. Ms. Meyer, as you pointed out, the bill as drafted puts the burden on the convicted person to come forward at the appropriate time and file a motion seeking the sealing of his or her records. And you've indicated that's highly inequitable. If the burden were not upon the individual himself or herself, who would bear the burden of notifying the previously convicted person that the time has passed, the conditions of the sentencing have been fulfilled, and all the other criteria have been satisfied by the way, you have the option to do this under the current statute. Are you suggesting that the court system should bear that burden and track all convictions over the year?
No, certainly not. That would be almost an impossible task. But
Right.
I do think it's the responsibility of defense counsel to let their clients know that this is an option for them.
Yes.
And so many of Maine's defendants go through the Indigent Legal Defense Commission for funding. It could be part of that process. And there are processes set up in other states where then if a defendant wants to seal their conviction, they go to the criminal window at their local courthouse, they fill out a piece of paper with the details. The judge then goes and pulls the file, looks at the reasoning and the argument for sealing, and makes a decision on a case by case. It costs the defendant nothing.
Yes, but given the fact that that at least 4 years must pass, and possibly longer, depending upon fulfillment of the restitution and so forth, even if the attorney present at the guilty plea or verdict hands out a paper saying, here are your rights to seek sealing at some point in the future, a person's likely to lose that piece of paper and not continue that knowledge, forward into the future. So I guess I'm just not sure how meaningful notification is given to a convicted person.
Well, I do understand your point, and it's a good one, but I also know that when defendants are convicted, there is a host of instruction issued from the bench about their rights. I've sat through many a hearing to hear judges say this in varying levels, but a judge could also reiterate, when you plead guilty to this, or when you're found guilty of this, this is your absolute right under state law to seek seal of your criminal record in 4 years' time. If a defendant is in the courtroom paying attention, as everybody in that room assures that they are, I think that's adequate information for them to know. And then it's up to them, should they want to pursue it.
Okay, thank you.
Senator Sanborn?
Thank you, Madam Chair. My question relates to your statement that the committee hadn't reached a decision with regard to sealing versus expungement. And it seemed to me that you were implying that there was a preference on your part for expungement instead of sealing. But I wasn't clear if it was just a procedural objection or whether you were making an argument that we were choosing the wrong option with regard to this bill. So I guess that's the first part of my question. I have a follow-up.
Okay. No, it was really more procedural that we discussed. I think it took hours of discussion to look at what the definitions were for these certain things, how they're defined across the country in different states and under different state laws. And as a committee, we never came to a consensus on what path we wanted to take. This bill takes a certain path that was not decided at the committee level.
May I have a follow-up, Madam Chair? So my understanding from our briefing from the committee is that there is some constitutional concerns with the use of expungement. Is that your understanding as well?
That is my understanding as well, yes.
Do you think those same constitutional concerns come into play with regard to sealing?
I think there will be constitutional concerns if the seal is automatic, but on a case by case, there is not.
Okay, thank you.
Thank you. Representative Poirier?
Thank you, Madam Chair. And Ms. Meyer, thank you very much for joining us today. As a member of the committee, I know you didn't have time to actually share your whole testimony with us, and I just want you to have an opportunity, if you feel like there's anything else in your testimony that's important for us to hear, to give us that information, please.
Well, I was a little surprised to hear Mr. Kebeda explain that we were moving forward a recommendation to look at a bill that follows the process of 1459. That was not the motion I voted on. I voted on moving 1459 forward and asking judiciary to put it to public hearing that it had not had. And if we look at the testimony, much of the testimony for 1818 to continue the committee's work, it references continuing work on 1459. It does not reference continuing work on a like 1459, but specifically to 1459. And really, if this is about marijuana, let's narrow it to marijuana and not the universe of Class D and E misdemeanor crimes. That was also discussed but not decided.
Thank you.
Representative Reckitt?
I just wanted to chime in on the question that Senator Sanborn asked, because I have been involved in expungement discussions, not on this particular bill, but on a bill that I did last year. And it was clear to me at some point I took out expungement because of the constitutional concerns and the, and the stepping into the governor's territory problem. So I just wanted to pass that on. That's all.
Thank you. Representative Moriarty?
Thank you, Madam Chair. Ms. Meyer, I'm not sure who may be behind you in line to speak, but I wonder, can you address the disparity in the standard of appeal to the law court? The state may appeal as a matter of right. A petitioner may appeal only as a matter of discretion. How was that arrived at? If you can shed any light on that.
I can shed no light on that because we did not discuss that as a committee. And while I'm not a lawyer, much to my father's disappointment, I cannot explain the language or how it was presented or why it was presented.
Okay, thank you.
Committee members, any additional questions? I had one question, and you spoke before about wishing there had been a hearing on 1459. And again, that bill was, for procedural reasons, voted ought not to pass. Can you highlight for us the differences between this proposal and 1459 that you think are relevant to our consideration and would be reasons why we would either, what are the distinguishing features? I think is an easier way to put it.
Well, the distinguishing features in my quick, paragraph to comparison last night is the Maine Press Association's recommendations were included. Those concerns about making, say, for instance, if a journalist were to publish now confidential information or had published information that is now confidential, would they be held legally accountable for that? Those two paragraphs have been removed from this, but otherwise the bills are really quite similar, except for the settling on the ceiling option. MFOIC's concern is really more about the inequity here, about the cost factor for defendants. And I wish I could find statistics on this, but I would hesitate a guess that the majority of defendants that move through Maine's courts are either indigent or low income enough that they need to get defense help. They are not hiring their own lawyers. So we would be imposing this statute on them knowing they couldn't pay for it, which seems, it just seems unrealistic. And our position is there's a better way. And had we, as a committee, a Criminal Records Review Committee, had the time to sort through a better way, we would have come to a consensus and brought forward a bill that everybody could have been behind. 1310 does not incorporate any of those recommendations or discussion. There's no hint of it in here.
And I have one follow-up for you, which is you had mentioned before the Massachusetts process. Is that to you the ideal alternative to the process that's included in 1310?
I don't know that I specifically referenced Massachusetts, but there are a number of states that do this on a low cost or no cost basis. We did, our wonderful staff did put a grid together for us so we could look at those options. But as a committee, we read the grid, but we never dove in. And that, I think, is regrettable, but it was a lapse of time issue.
Thank you. We'll follow up with getting the grid. Thanks for mentioning that. Committee members, any final questions for Judy Meyer? Not seeing any. Thank you so much for appearing today. Next, we'll hear from Peter Lehman.
Good morning. I'm Peter Lehman. Can you hear me?
We can hear you just fine. Thank you very much. Welcome to the Judiciary Committee.
You surprised me a little because I'm testifying neither for nor against.
Oh, I thought you had your
Carney.
hand. I'm sorry to interrupt you. I thought you had your hand raised for in opposition.
If I did, it was by mistake, and I don't believe I did, but
okay.
Sorry about that.
Let me.
Do you have any more in opposition?
Well, I'm just going to ask you to wait one moment and stay on, keep on the panel. And I'm just going to see. Just
Thank
one
you.
moment, please. So at this point, I'm turning to those in the attendee portion of the meeting. I don't see anyone who hasn't already spoken to us. So I think we're done with the opponents, and Mr. Lehman, you can proceed.
Okay, thank you. I'm a little bit on the road this morning, listening to this Senator Carney, Representative Harnett, distinguished members of the committee. My name is Peter Lehman. I live in Thomaston. I'm a formerly incarcerated citizen and a person in long-term recovery. I'm testifying on behalf of the Maine Prisoner Advocacy Coalition, whose goal is to promote restorative practices in order to increase public safety and the health of our community. Criminal convictions, as you are aware, are life sentences because of the way we deal with criminal records and making them easily and indiscriminately available to the public. Sealing criminal records such as authorized by this bill will benefit everyone. It makes it more possible for a reformed offender to rejoin society and provides the community with needed and productive workers and tenants. We urge you to support this bill. So what are the reasons why I'm testifying neither for nor against? Well,
Peter Lehman, I think that you inadvertently muted yourself. Can you unmute and then back up a couple sentences, please? Committee members, I'm going to try to help Peter Lehman unmute. Just give me a moment here.
Is to make them confidential under the Criminal Records Act already in Maine statute. Now, that's a fascinating category because it means that those records are still available to criminal justice agencies and court agencies, and they also are available to employers or licensors, such as the Department of Human Services, who are by statute allowed to look at the confidential records. So, for instance, some of the exceptions that people talk about are exceptions for sexual offenses, and people hiring, for instance, for childcare would have access to the confidential records. And secondly, as and Ms. Mancuso already argued eloquently for the notion that that we should be talking about making all those records confidential after 4 years. It also seems to us that there should be automatic sealing, and you've just talked about that. And the fact that the petition process effectively limits benefit to those people with the means to pursue petitions. Yes, I'm in a meeting. Sure. Sorry.
That's all right, Mr. Lehman. Your 3 minutes has passed, so if you could please wrap up, and then we'll have some committee questions for you. Thanks.
We're simply suggesting that we do this automatically. Other states do that. It would make it cheaper. And we think that the committee can amend this and make this an even better bill. Thank you much. Appreciate it. As you can tell, I'm caught in the middle of a automobile repair.
I hope it goes well, but let's see if we have committee questions for you. Hang on one moment. Committee members, any questions for Peter Lehman? I'm not seeing any, but I have one for you. I think that you're quite familiar with this issue, and you've probably heard some of the conversation about the Maine constitutional issues with regard to automatic sealing and expungement. Do you share those concerns? Do you have a suggestion for how automatic sealing could happen without running afoul of the Maine Constitution?
Well, I think that for one thing, we need to chuck the word sealing, since we don't understand what it means. And because there are many definitions. There's already a category in Maine statute called confidential, and that category is what this bill proposes to use. That those records would become confidential, and that can be reversed under certain circumstances. So it seems to me that that's the way around that legal issue. I know attorneys have various perspectives on reading the court case that on which that issue is raised. I personally think that the confidentiality one statute would take care of that problem. And after all, nobody knows until the court actually deals with it. And I understand that the primary task of legal training is to help people assess the probabilities that the court will agree with what you wanted it to do. And I think that this is a good shot.
Thank you very much. Committee members, one final check-in to see if anybody has questions for Peter Lehman. I am not seeing any questions for you. Thank you so much for testifying before the committee this morning.
Okay, thank you much. Appreciate it, and have a great day.
And I'm looking at the attendee space. There is no one else present who wishes to testify on this bill. And so I will close the public hearing on LD 1310. I did want to open the floor for committee members to suggest information that they would like our committee analyst to gather for the work session on this bill. I know that Representative Libby made one suggestion that was really helpful. And I think that the chart that was referred to as well, I think by Judy Meyer. Peggy, if you could also get that for us, that would be helpful. Committee members, are there other pieces of information that we would like available for the work session or prior to? Representative Moriarty?
Madam Chair, I just wonder whether some of the questions can be conveyed to the sponsor. For example, my question on the standard of appeal and some others that were raised. She may be in a better position to respond. And just one minor point along that line, the slight conflict between the summary and the text of the bill itself, in that the summary says that if a petitioner is successful, the court may seal the records. but the statute clearly says that if a petitioner is successful, the court shall seal the records. And we can't live with that kind of inconsistency. Or can't go forward.
Thank you. We will look into both of those things. Thank you for raising them. Representative Newell?
Thank you, Madam Chair. My question would be, based on the testimony that we just heard, in regards to the cost in filing a motion. I think if we can have some helpful information relating to the cost, and is that a limitation?
Thank you. Any other information that we feel would help us in the work session? Great, thank you. We're just about done our work for today, but I did want to raise one other matter for committee members, and if you can just give me one moment, please. We received yesterday a memo from the presiding officers about committee decorum. And I will be sending that memo to all members of the committee and ask that you carefully read it. And if there are any questions or concerns you have about the matters that are made in that memo, encouraging committee members to follow the rules of committee decorum and to continue to work as required by the rules of decorum, then you can bring them to my attention. I also want to just highlight that we've all been working really hard this session, and we've done a lot of good work. And I think that is because we do think about decorum in this committee. And I'm appreciative of all of the work that you've done and the decorum that we've all exhibited, and would just like us to, keep working well together and respecting each other. And don't think I need to add anything else, but I'll be sending it shortly after this meeting, and everybody can take a look at it and ask any questions you have. Thank you all very much. Representative Thorne?
Thank you, Madam Chair. Was there something in specific that had prompted you to write this letter, or was it just in general?
So I did not write the letter, and I'm not sure what prompted the presiding officers to send it, but you'll see it in a moment, but it's a memo sent from the presiding officers to all Senate and House chairs of all joint standing committees. And so, again, I'm not referring to anything specifically that's happened in this committee.
No, I was just asking that I received if there was something that had happened in a committee that had prompted this letter, or something that, more specific, while I had the opportunity to ask you, rather than try to extract it out of the letter.
Yeah, let me just finish my answer. Yeah, it's not, as far as I know, I don't know what initiated the distribution of this letter. But I do think it's good for all of us to have a reminder, and that's why I'll send it to all of you. And again, if you have questions, I'm happy to answer them.
Thank you.
Any other questions, committee members? Representative Senator Sanborn, excuse me.
Do we still have a public hearing at noon today?
I thought it was at 1. Oh, it is. Thank you for reminding me. Yes, it's at noon on LD 1950.
Okay, you had said we were almost done with our work for the day, so I just wanted to make sure that was still the case. Thanks.
Yeah, I was confusing the day and the morning. I'm glad you highlighted that. And I had said the inaccurate time earlier today, so we're reconvening at noon. Representative Sheehan?
Thanks, Madam Chair. I just wanted to let the committee know that I have a prior obligation from noon until 1:30, but that I'll rejoin the proceedings after.
Thank you very much. Anything else, committee members? Peggy, did you have anything for us before we recess? Okay, so we'll be at recess until noon, everyone. Thank you.
See you then.
Log on to a Zoom meeting, so I just gotta.
Good afternoon, committee members. We're just before starting time, but as you return, if you could please activate your video so that I know that you are in the room for a quorum. Just waiting for a few more members of the committee.
Hello, Representative Harnett, my co-chair. I know you were waiting for me. I just wanted to let committee members know that I will be introducing this bill because Representative Cardone isn't available. And I'll thank you in advance for your patience because I did not prepare introductory remarks. but I'm happy to talk to you about the bill when the appropriate time comes.
Thank you very much, Senator Carney, and I will explain why that is necessary today. We have 8 members. I'm just going to wait to see if we have a few others pop on. Okay. And I will check with the committee clerk to see if we are we live, Supi?
I think we are, Representative Harnett, because I see on my screen anyway, I see the little icon that says we're
Okay,
live.
and I'm on a different computer than usual, and it says in big block letters live. So that should probably tip me off. Good afternoon, and welcome all to the afternoon session of the Judiciary Committee for February 9th, 2022. My name is Tom Harnett. I serve as the House co-chair. And in a moment of true confession, about 20 minutes ago, I picked up LD 1950 and realized that because of my status as House chair, and this coming from a committee, that I am the person to report it out. Made a panicked call to my distinguished co-chair, who fortunately served as the Senate chair of this committee, and she has agreed to introduce the bill, and you will be hearing from a lot of experts as well. So I apologize for that error on my part, but what we'll be doing this afternoon is having a public hearing on LD 1950, an act to implement the recommendations of the commission to create a plan to incorporate the probate courts into the judicial branch. It's LD 1950, and I would call upon my co-chair, Senator Carney, to introduce the bill. Thank you.
Thank you very much, Chair Harnett and members of the committee. It's wonderful to be here with you this afternoon to talk about LD 1950. As I mentioned earlier, I did not have an opportunity to prepare remarks, but I did co-chair the commission, and I'm very excited to talk to you about this legislation. I'm going to start with sort of a big picture approach. In the 1960s, and I don't have my reading glasses on, so I'm not seeing the exact date, but I believe it was 1967 because I think I was 4 years old at the time. The voters of Maine approved an amendment to the Maine Constitution to revoke the constitutional provision that requires probate judges to be elected. That revocation of the elected probate judges was contingent upon the establishment of a system for full-time appointed judges under, and it didn't specify that they had to be within the judicial branch, but that is the path that we took as members of the commission. So that constitutional amendment has yet to be implemented. There have been many, many studies over the years regarding the benefits of moving the probate court system into the judicial branch, but none of those studies ever really advanced the transition and implementation of that constitutional amendment. And so what Representative Cardone did when she proposed legislation to this committee in the first session was that the objective specified in the title and running throughout the legislation was that the commission was not to study whether this should happen, but was actually to come up with a plan for how it would happen. And so commission members worked very hard. We didn't always agree with each other, but we sort of kept ourselves focused on what would the plan be and not second guessing the will of the voters. And so the plan we came up with was twofold. First, we heard a lot of testimony that the way the register of probate system works is working well within our state. Registers of probate are elected county officials. They run the sort of non-court side of the probate offices, and they do things that typical judicial clerks don't do. They provide a lot more assistance to people who come to the courthouse seeking help than a clerk would do within the judicial branch. And so we decided to preserve that. It was working really well. We didn't think it needed any fixes. With regard to the probate judges, however, that was a really important part of the constitutional amendment. And it was something that we felt there was a lot of room to improve. Not because there were any concerns specifically about any probate judge or any county probate court, but because, as we heard in some other legislation that we considered in the first session, probate judges miss out on a lot of things when they are elected judges as opposed to members of the judicial branch. For example, the judicial branch judges within the judicial branch get extensive training opportunities. And you'll probably recall that we heard a bill where probate judges wanted to participate in the judicial branch training, and also heard from the judicial branch that the problem with that is that those probate judges also have private law practices. And so they would be put in an advantageous position vis-a-vis other lawyers engaged in private law practice if they attended the judges only training. And so judicial training is one reason why we would want to make the transition. The other is that it gives us an opportunity to have full-time probate court judges available to meet the needs of Maine people. We also took the opportunity to identify ways to relieve counties from the financial burdens of appointing counsel when that's required in probate matters, when indigent people come before the probate court. And so there were a lot of opportunities to address those concerns. We took them all into account and we came up with the legislation that is before you. And with your patience and permission, I'm just going to go through and sort of highlight where the major changes occur. So you'll see that, well, first of all, there is actually, I think rather than going through the bill itself, I'll talk about some of the highlights. So the first matter is how would the new probate judges within the judicial branch work? And what we did is we decided to establish ultimately 9 probate judges within a specific probate court within the judicial branch. 8 of those judges would cover the same territories that are part of the judicial branch districts currently. And then 1 of those judges would be a chief judge. Now, currently we have elected judges with staggered terms. And so we prepared a transition plan that ensures that no elected probate judge would have to leave his or her elected position in order to prior to the end of the term. So there will be a smooth transition process that takes place over the course of the next 3 years. We also, I think maybe what I'll do is I think I'll stop there because that kind of gives you the lay of the land. We'll have a 3-year transitionary period. And at the end of that, we will have a chief judge of probate. And then we will have 8 probate judges assigned to the 8 judicial districts. And in addition to that, within 4 years after that implementation process, we'll have a review process to determine whether the system is working appropriately. One of the concerns was that probate matters might be delayed or put on the back burner if the probate courts are incorporated into the judicial branch. And for now, none of the 9 new judges would perform any duties associated with other judicial branch functions. They would exclusively be focusing on probate court matters so that we can really assess what the needs are as far as level of judge time in those probate court matters and whether there was any capacity to allow those judges to take on other civil or criminal matters in the district courts. So I think I'll stop there and just invite you to ask any questions.
Thank you very, very much, Senator Carney, for introducing this bill on my behalf. And I will now turn to committee members to see if there are any questions for the Senate Chair of the body that issued these recommendations to incorporate the plan. So I will look for electronic hands. And I do not believe I am seeing any. If I am missing anybody, if you could please raise your physical hand so that I know you have a question. And seeing none, thank you very much for your introduction of the bill, Senator Carney. And I am now going to follow our typical process in a public hearing of calling on those persons testifying. I'm sorry, Senator Carney.
I just wanted to make one other remark to the committee. This
Please.
legislation was drafted by our OPLA analyst, Janet Stocco, and she is quite the expert in these matters. And I think that as we complete the public hearing and open up a work session at a later date, we'll be able to screen share and go through each line of the bill and respond to any questions you have. Thank you.
Thank you for that recommendation. And on that note, this is a 46-page bill. And I see that we don't have very many people signed up to testify orally. I am not going to invoke the 3-minute clock, just given the depth of this proposal. I would just remind the committee that in our electronic file, we have the final report of the commission dated December 2021. I would obviously encourage us all to review that again. And there is also an extensive amount of written testimony that has been submitted that would guide the committee as we continue to work on LD 1950. And with that, I will turn to the attendee room and ask if there are persons in the attendee room who wish to speak in support of LD 1950. If so, if you could please raise your electronic hand and I will have the clerk move you over. And the first hand that I see raised is Leo Delicata. And I would ask for Mr. Delicata to be moved over and also Debbie Willis to follow. And as soon as they are over, I will call upon them. Leo Delicata, welcome back to the Judiciary Committee. Thank you for being here to discuss LD 1950 today. As I said, we don't have the 3-minute limit, but if you could summarize your comments in a reasonable period of time, that would be very helpful to the committee. So please begin your testimony when you feel comfortable.
Thanks very much, Representative Harnett. This would be the day when you didn't have a 3-minute limit. Representative Harnett, Senator Carney, and members of the Judiciary Committee, my name is Leo Delicata. I'm a lawyer with Legal Services for the Elderly, and I had the honor of serving on the commission to create a plan to incorporate the probate courts into the judicial branch. As you know, the recommendations that we made are included in this legislation, and I'm here to restate my support for this implementation plan. And if I might, I'd like to share some realizations I had as the work of the commission progressed. You've heard about the satisfaction with the probate register's office. They're very competent. They have the time to spend to answer questions from consumers. They explain to people how to fill out the necessary forms to get a particular service from the court, and they are generally extremely helpful. And that's why the commission decided not to recommend any changes to the register's role or the register's location in each county. So each of the 16 counties will continue under this plan to have a register and an elected register and an office paid for with county funds. The new probate code has changed the way that guardianships and conservatorships are viewed and demands more of every professional involved. And that's really what I'm talking about today. Problems with the probate court as it exists now that you really can't see if you're the typical consumer that comes in and deals with the registrar's office and really walks away saying, what great people, what tremendous service I've just had. And a lot of it stems from the new probate code. We went from a system where a default order was a full guardianship or a full conservatorship to a system where the least restrictive measure is required in order to meet the particular need of a particular individual. It's very, very person-centered. A limited guardianship or other protective arrangement is now the default. And probate courts are challenged to find visitors who are able enough to produce a culturally competent person-centered assessment, deliver and explain a petition, and ensure that the individual understands their rights. We've heard this from registrars. We understand it. Most probate courts have still not been able to pay more than a token fee for a visitor service, and that limits the pool of candidates. Probate courts are equally challenged to find lawyers willing and able to take appointments in guardianship and conservatorship cases. And the fees that they pay are not adequate to attract most lawyers to that work. There is a remedy for that in this bill, and it asks the Commission that provides indigent legal services to also include probate matters in their scope of practice and to be responsible for training, assuring quality, and paying out of the general fund those attorneys that are appointed by the judges who now, under this system, will eventually all be appointed judges. There's another thing that is there but not seen, and that is the unequal ability in all probate courts to monitor what's happening in cases where guardians or conservators have been appointed, even when an annual report is required. And they, not all of them are required. There's no system to determine whether a return in-person visit is indicated or how the individual who is under guardianship or conservatorship feels they've been treated. The point in all these examples is that there are problems in the existing probate courts that are not really visible. People don't complain when their visitor is ageist or doesn't take the time to do a complete assessment. Nobody knows if their lawyer is less than aware of the provisions of the probate code, so they don't know what kind of representation they're getting. Guardians or conservators are certainly not eager to be questioned about their doings. And individuals subject to guardianship or conservatorship may never have had an opportunity and may still not have an opportunity to tell anyone that they are happy or not happy about how they're being treated. The proposed legislation will address all those problems. It's going to take time and money. The counties, I think, are not the source for this money. They're funded indirectly by the taxes that homeowners pay to their municipalities. The last thing anyone, especially an older adult, needs is a larger property tax bill. And I think that's one of the realizations that came, I'm ashamed to say this, came late to me, that the probate court system that we have now is property tax based. It has nothing to do with the general fund. So it's homeowners, not even business people in general, who don't own property, that end up paying for the probate courts. The judicial branch is funded through the general fund. That fund is income tax based and is paid by individuals and businesses. The impact on older adults and most middle income people will not be overly burdensome, and we will have a better chance to build other probate court services up to the level now offered by registrars and their staff. Thank you very much for giving me the opportunity to talk to you today, and I'm more than happy to answer any questions. Thank you.
Thank you very much, Mr. Delicata. We appreciate your being here this afternoon and your service on the commission. Are there questions from committee members for Leo Delicata? If so, if you could please raise your electronic hand so that I can recognize you and call upon you. And I am not seeing any. If in the event I'm missing anyone, if you have a question, please raise your human hand. And seeing none, again, thank you very much for your time and testimony today and for your service in developing this plan.
Thank you.
Greatly appreciate it.
Bye-bye.
Next, call upon Debbie Willis from the Office of the Attorney General, who happens to be my constituent as well. Welcome, Debbie.
Thank you, Representative Harnett. Senator Carney, Representative Harnett, members of the Judiciary Committee, I'm Debbie Willis. I'm the Division Chief in the Child Support Division here in the Office of the Attorney General, and I'm here to speak in favor of LD 1950, an act to implement the recommendations of the Commission to create a plan to incorporate the probate courts into the judicial branch. The Office of the Attorney General offers a perspective on this LD gained from my Child Support Division's involvement in family matters in both probate courts and the district courts across the state. I litigate the same subject matter in both courts. These sensitive and critical family matters would benefit from the efficiencies, the uniformity, and the support of having the probate courts incorporated into the main judicial branch. The judicial branch jurisdiction has been expanded recently to include guardianships and name change cases. The family division of the district court does a particularly superb job of handling family matters with efficiencies developed to swiftly move family matters forward into resolution, providing stability for families and children. Another benefit for our client agencies, families, and other litigants is that the probate cases will be handled as part of a centrally administered system of justice. This would provide consistency in procedures and training, as there would be a centralized staff and administration. Today's family matters can be really challenging and complex. Families would benefit from having full-time judges who could dedicate all their time to their judicial work and not have to maintain a private law practice or some other form of employment. Family matters could be allocated according to the number of cases, not along county lines. The judicial branch could apportion resources where needed throughout the state, which would help prevent delays in having cases heard and resolved. Finally, this is a phased transfer. The judges will transfer over the course of 4 years. They will work in the existing probate court facilities. The county registries of probate would be preserved. They will do docket and scheduling of the court proceedings. They will assist parties in completing probate forms and perform quasi-judicial functions in informal probate matters, something district court clerks are not authorized to do. Additional time and consideration is needed to determine how best to preserve these features. Thank you for your time today. This is a very complex and important initiative, and I would be happy to address questions now or at any work session. Thank you.
Thank you very much, Debbie Willis, for your time here today. We greatly appreciate it, and it's nice to see you. I will now call on committee members with questions, beginning with Representative Evangelos.
Thank you, Mr. Chair. Hi, Ms. Willis. I just wanted a clarification on a point. Will the physical place where the probate people are now operating stay the same? Are they going to?
Yes, it will. Representative Evangelos, same folks, same location, same courts for now. Yes.
There's not going to be any struggle for space or anything.
No.
Okay. Thanks a lot.
You're welcome.
Thank you, Representative Evangelos. Any additional questions, Representative Evangelos?
I'm all set.
Okay, thank you. Representative Moriarty.
Thank you, Mr. Chair. I'll follow up on the previous question, Ms. Willis. I note that there are to be 8 probate court regions as opposed to 1 court per county. So there is to be 1 judge per region plus a chief judge. Am I correct?
That is correct, Representative Moriarty. There'll be 8 in the regions, and 1 will be a chief judge.
Now, I'm just wondering, is there the position of chief judge is a full-time job in and of itself? Or
Yes.
will that be sitting as needed elsewhere?
I'll get an answer for that for you. Generally, right now, the chief judge doesn't sit in a courtroom, Your Honor, Representative Moriarty. But I will make sure that I have the correct answer for the probate.
Okay. And some of the regions obviously include more than one county because we have 16 counties, but 8 regions. Do we know which county in a multiple county region is going to be sort of the headquarters, or is that even, does that question make any sense at all?
That question makes perfect sense. And I don't know the answer, and I'll find out for you. I don't know how they're going to split them up. I know how they are currently, but I don't know what they're going to do going forward. I'll find out.
Okay. And I'll just continue on with one more anyway. I know that a probate judge is to be in Washington County really fairly infrequently during the course of a calendar year, but as I understand it, and I think it's been explained, there's still going to be a full-time register in that
Yes.
county. Okay.
Yes.
Will there be enough work for that particular judge to do? I see that Washington is blended with Hancock in Region 7. Is it your estimate that will be a workload equivalent to everybody else's?
I have a feeling, Representative Moriarty, that's what's they're going to be following that as this rolls out to see if that is, because I saw a provision that would allow them to do other work, not just be only doing probate. So if they're, 50% of the day took probate, they wouldn't be just sitting there the other 50%. But I'll make sure of that too. So that they would stay busy full time. You wouldn't have a district court judge without a significant enough case, I call it a caseload, but a judicial calendar so that they were not busy all the time.
But when you say other work, just to be clear, they would not be doing private practice.
No, sir. By that, I mean other district court cases. Maybe they would be seeing some of my family matters or something like that.
Okay. Okay. Yeah. All right. That's helpful. Thank you.
Thank you.
Thank you, Representative Moriarty. Senator Carney.
Thank you. I would request your permission to answer a few of or supplement the answers to Representative Moriarty's questions.
Absolutely, Senator Carney, please.
Okay. We spent a lot of time and energy on the transition and allocation of work. And so I just wanted to, and some of that was in discussion. So I wanted to clarify it. First of all, the chief judge of the probate court would indeed be a chief judge. There might be some incidental presiding over matters, but that judge would not be assigned to one of the 8 judicial districts that currently exist in the state. The regions would mimic or be identical to the existing 8 judicial branch regions, which are also correspond to the prosecutorial districts in Maine. The kind of awkward thing one might say is that if you look at the terms at which judges are elected, they're not consistent within each one of those districts. And so for 2 years, there will be a little bit, things will be allocated a little differently than they will be once the plan is fully implemented. Regarding the full-time judge in Washington County, and I can also get this for the work session, as well as the information that Debbie Willis is going to get. But as I recall, so we did a very careful study of how much judge time was needed in each county probate court. And then we took that into account along with the expiration of terms of elected judges in formulating the transition plan. And it is absolutely accurate that we won't have, that the judges will all be full-time and they will be busy, but we think that initially some of that judge time will be spent coming up to speed in probate, the way the probate court matters are held, and kind of helping with the transition. But at least until the study is done, several years after full implementation, the probate judges would not be doing other district court work because again, we want to get a handle on what is needed by way of judge time for the probate court matters and make sure that they receive the priority that they're entitled to and that the people of our state want them to have. So at least initially, they will only be doing probate court matters. There won't be any jurisdiction for those judges to handle other matters.
Okay. May I follow up, Senator Carney?
Yes, unless Senator Carney, did you have a question for Ms. Willis, or may Representative Moriarty follow up with you?
That's fine. I'll try to help.
Go ahead, Representative.
Okay. I have a question about the pay scale for the probate judges, at least as the system begins to unfold. Will they be paid at a rate congruent with district court judges, or what does the committee foresee?
The information we have, and I have a binder that's about 6 inches thick behind me that I'm not going to pull out and look through, but
No.
we use as figures for pay scale the pay scale for judges, and I'm not sure whether district and superior court judicial officials receive the same pay rate or not. I don't know, and if they're different, I'm not sure which one we picked, but we can get that for the work session. But then there are also other staff that would have to be hired, a magistrate, and each judge would have, I believe, a quarter or a half of a law clerk. And then there would also be a clerk. And we used the current figures provided by the judicial branch for all of that.
I see. Okay, thank you.
Thank you. And did you have questions in addition to your comments, Senator Carney? Thank you. Senator Keim.
Thank you. Nice to see you, Ms. Willis, as always.
Nice to see you, Senator.
I have a question. It seems, so it's a more broad question, but listening to your testimony, it seems that you're indicating that the probate courts are not doing a good job in some areas, because you're saying that of course the judicial branch is going to do this so much better. And so I guess I need to understand the vagueness of that, is difficult for us to, decipher. And right now I'm looking at judicial branch backlog, which is significant, and the probate courts do not have anywhere near that. So I was wondering if you would comment maybe more specifically on where you see that the probate court is failing the people, because that seems to be what, is behind your support of this change.
Okay, Senator Keim, I'm struggling with the word failing. I would say this, Senator Keim, I have the luxury of having a statewide practice. So my folks are in all 16 counties. So I see things all the way from the top of the state to the bottom of the state. So I can make comments without a particular judge knowing that I'm talking about him or her. And I don't think so much that it's a failing. I would say that things have become incredibly complex, that over the years, and I think, Senator, since you've been in the Judiciary Committee, we have now the home court of the child. We have now so many family matters are being heard in the probate court, the guardianships, caretaker relatives, other folks coming forward. We have added over the last few years through statutory changes, additional workloads. Also, family life has become far more complex, and we're asking them to handle these cases while at the same time they're also in private practice and doing other things. My division, I get inconsistent results depending on which county we are filing in. And I can see that because I have a statewide practice. But I also appreciate this, Senator Keim. I recently had to go to the probate court in my Piscataquis County. I think that I want to give a shout out to Piscataquis County and to Kennebec County, And I would say probably every constituent would want to do the same thing. When you go to the county courthouse, the registrar and his or her staff are amazing, helpful. And I truly appreciate what Piscataquis County just helped me do personally. And I'm already an attorney, and I greatly benefited from their ability to help me do something that I don't do on a regular basis. So that's, I think, I would like to see, I understand why people, I also think highly of my own individual. I'm going to claim Kennebec County where I live and Piscataquis County where I grew up. Is that helpful, Senator Kayam?
Yes, it is, but it sounds like then you might be saying that the fact that the attorneys that the probate judges have divided attention as far as like having to balance whatever, since they're part-time. And that seems like where you're pointing the issue to be with. Is that correct?
That's one of them. And I'm just going to be frank, Senator Kime, and tell you, so there is a probate judge that refuses to issue a child support order in a family matter, even though the statute requires that the probate court issue an order. I can file in a contiguous county if that happens. If I want to have a child support order, I don't think that should happen. I think that every family deserves, I have one line of work, Senator Kime. I think every family deserves to have a child support order, or at least to have the court address it. Also, there are this probate court where most of them have set dates, and leaving COVID out of this, Senator Kime, just talk about in regular. And there was a judge who decided that there wouldn't be regular dates. So the court's held when the judge wants to hold it. There's another case, I want to call you Your Honor too, Senator Kime. There's another case in which I had a very hotly contested child support order against someone who is now a sitting probate judge. And my staff has to prove to this now judge that we have a capacity and ability to be present in a probate matter to get a child support order for someone. And those are very difficult things. Those are very difficult. And it's unique to my practice. I can't speak to other things that go on, but in the child support world, those are some of the things that I would say that make it difficult in the probate court. For me personally, if I had a problem with a judge in the judicial branch, I just have to bring that to the attention of the chief judge. I walk away. I never know what happens. It's just like a personnel issue in my office. I wouldn't go back and tell. I just know here's my issue. It's incredibly rare that I would ever have to do that. But if I did, that's what I could do. Now I would have to seek out 3 county commissioners and I guess bring it to their attention. I don't, but I'm being very frank with you, Senator Kime, and telling you my personal practice over my 15, 16 years of this.
Yes, thank you for that. And one more question, if I could.
Yes, you may. Go ahead.
So then the other thing that you mentioned is the registrars are pretty phenomenal in general. And I know that the people of Maine really appreciate that down to the earth sort of response as they, walk into that court. Generally, very helpful. And but the registrars do work for the judges, and they provide a good service. So there's been some conversation around the difficulty of the idea of leaving the registrars to be as they are, which is elected, and then they supposedly work for a judge who is appointed, and that difficulty there. Plus, I don't know if we changed it, would they then would their hands be tied, right? So if we lose them, right, would their hands then be tied that they couldn't do sort of that quasi-judicial sort of like discussions with the people that come into the court? I wonder if you could just comment on those two things.
Yeah, I think that's going to be part of what they're going to be looking at and reviewing going forward, Senator Kime. And so to give the other members of the committee, when we talk about quasi-judicial, what's really important is if you're doing an informal probating of an estate, whether it's with a will or without a will, currently the registrar can appoint you to be the representative of that estate, or we call it executor or executrix. A district court clerk wouldn't be able to do that. That would have to be done by a judge. And that's one of the really valuable things that the registrars do. And I don't know the answer about what that's going to look like going forward, Senator Kime. I think that's what they're going to be looking at, because that's really they do a lot. I mean, the registrars, and they do a great job with it too. That personal service right to their constituents, their residents right there.
Thank you so much. I appreciate all those answers.
Thank you, Senator Kime.
Thank you, Senator Kime, and thank you, Debbie Willis. Representative Evangelos.
Thank you. Thank you, Chair Harnett. So this question's for Ms. Willis and for Julie Finn. Sorry, my throat's clogged. I just want your assurances or your knowledge and opinion on this. We've been through these Maine Commission of Indigent Legal Services matters, and we've heard from a lot of lawyers, and then the justices came in, and there seems to be a consensus that there's 27,000 cases on the criminal docket. In total, there's 50-something thousand cases, and the system's under stress. So based on your vision and what you've done in the system, do you think that the probate part of this will just fit in seamlessly, and those deficiencies in those areas won't impact the merging into the judicial branch?
I'll leave it for Julie Finn to talk about the finance, but what I would draw on, Representative Evangelos, is I've been at my job long enough to remember when they created the family division of the district court, and we have the 8 magistrates that we have now. Representative Evangelos, before we had the family division of the district court, it could take 2 years to get a child support order. It just would. No, we just would. But in the big district court system, and I don't know that that's a reflection of the caseload or whatever it was. But so they created the family division, hired 8 people to work with that, and they are amazing. We have child support orders within 3 to 6 months. And when I look at the probate court and what they're doing, Representative Evangelos, that's what it's going to be like. Here are the probate cases. They're going over to these probate judges. These probate judges are going to learn all there is about probate, and they're going to be dedicated to doing the probate. They're not going to be in small claims court. They're not going to be in the criminal court. They're going to have their own. I see their 8 judges just like I call them my own 8 magistrates, that they'll be dedicated to that work, and that work will get done.
Yeah, that's what I was looking for. Thank you.
Thank you, Representative Evangelos. Are there additional questions from committee members? Representative Babbage.
Thank you, Mr. Chair. Ms. Willis, hello.
Hello, Representative Babbage.
I certainly understand the advantage of standardization of both education and accountability. I wondered if you could comment on me, and I mean informally, but historically a contemporary issue regarding the impact of elected probate judges. Has there been any, I wouldn't say conflict of interest issues, but what have been the ramifications of elected probate judges versus what we are about to have in the appointed? In other words, is that something that would be an improvement, or has that not been an issue in your conscious memory?
Well, to speak for myself personally, born and raised here and living here and now litigating here, I don't think it's the fact that they're elected is so much as what happens after they're elected, that they don't have the same training, education, support as far as like the judicial branch. I don't think I've not seen, at least not in my counties, I haven't seen that it was the fact that they were elected.
I didn't know if you saw an advantage or disadvantage, but the accountability being for their job to the people as opposed to an appointed person. In my own town, we had a major brouhaha about whether the town clerk should be elected or appointed. And that was a huge consideration. what I'm asking is, what about job performance? Does that, in your mind, or has it impacted the way the job is performed at all?
I'm struggling with the question because.
Well, I'm glad you
yeah.
are, because that may mean that has not been an issue.
Yeah, I don't think it's just they're elected. It's all these other things that play into it. The fact that they have to support themselves with another job, that you might be litigating against them in another county, the next county over. Those have been my concerns. And then, regular hours, the district court's open 8 to 4. I have a judge there. That's what I've seen, Representative Babbage.
Great. Yeah, that's what I wanted to hear. Thanks so much. I appreciate it.
Thank you, Representative Babbage. Are there additional questions from committee members for Ms. Willis? I am not seeing any. I do have one. And I was struck by one of the things in your testimony and then a response that you gave to Senator Keim. And you used the phrase, talk about the benefits of a centrally administered system of justice. And you pointed out that yours is a statewide practice covering all of the counties of Maine. And the reality, as I understand it, as I heard you, is you see different things happening in different parts of the state, and that sometimes consistency is lacking, and that on certain occasions, basic rules are not being followed. This centrally administered system of justice, could you expand on how you think that would alleviate those concerns? Or if it would alleviate those concerns?
I think the first and foremost, Representative Harnett, was they're going to have a judge in charge. They're going to have the probate judges will have a chief judge. And I believe that they will all be trained. I know that magistrates are all trained in the same way. And I keep going back to that. They're all given the same training. These are your responsibilities, duties. Here's the statute. Here's the rules. Here's your support staff. And yeah. So what happens now in the 16 counties is all those judges don't. I don't know if those probate judges talk, but the magistrates can all talk to each other, and they can all benefit from that education and learning, and the way that and their practices.
So presumably, then you gave the example of one county. We don't need to name the county. Yes. Where a certain type of order is never issued.
Yes.
That is the type of an issue that would be addressed if we had a centralized system, correct?
Yes, I think so. I think so, Representative Harnett. That would be something that you could bring to the attention of the person in charge of all of those folks and just park it there to say, I've got an issue with this.
Thank you very much. Are there additional questions for Debbie Willis? I am not seeing any. Again, thank you very much for your service in all things you do, and thank you for your time for the committee.
Thank you. Thank you, committee.
And I am now going back to the attendee room to ask if there are other persons who wish to speak in support of LD 1950 to please raise your electronic hand. And I see I would ask for Christopher Berry to be moved over as a panelist. Christopher Berry, welcome to the Judiciary Committee. Thank you very much for your time today. Please activate your microphone and begin your testimony when you're comfortable.
Yes, thank you. So thank you, Chair, members of the committee. I am Christopher Berry. I'm an adoption attorney in the state of Maine. I practice statewide. I'm a fellow of the American Academy of Adoption Attorneys. And I wanted to indicate that I did, in fact, support the bill to move the probate court into the district court. My only potential concern is I sincerely hope that the legislature fully funds the district court and that these new probate judges aren't pulled over onto other district court matters, particularly in a Part 3 adoption where there is a birth parent that is consenting to the adoption and an unknown parent or a putative parent that needs notice of the action. Time is critical. And with the Home Court Act, I do adoption practice in both the probate court and the district court. And there is a remarkable difference between the two courts. The probate court is extremely good at scheduling things quickly, efficiently, and sometimes before things are even filed. I have district court cases that are private cases where it's been over a year and we still don't even have permission to go out and serve known parents about a termination of parental rights. The district court and the probate court are very different systems. I certainly hope that the district court gets some additional training, but the probate court does do a lot of good things, and I certainly hope that that's not lost in the transition. And that right now with the initial transition plan, those 8 judges are supposed to work primarily on probate court matters, but with the criminal and civil case law backlog in the district court, there's going to be immense pressure to move them on to other matters. And that's my fear, that the part of the systems that work now won't transition over. But I do think that overall it would be a good change for the state of Maine. Thank you.
Thank you, Mr. Berry. And I failed to mention this at the beginning of testimony. Could you please state your town of residence?
Oh, certainly. I reside in Bridgeton, Maine, which is in Cumberland County.
Thank you very much. And moving forward, if people could please, when they introduce themselves, and let us know where you are from and if you represent any particular agency or entity. But thank you, Mr. Berry. Are there questions from committee members for Christopher Berry? If so, please raise your electronic hand. And I am not seeing any. So again, thank you very much for your time this afternoon. Greatly appreciated.
Thank you.
I will go back to the attendee room and ask again if there are any persons who wish to speak in support in favor of LD 1950 to please raise your electronic hand. And I am not seeing any, so I will now turn to persons who might be opposed to LD 1950. And if there are any in the attendee room, please raise your electronic hand so that I can move you over as a panelist. Again, I see none, so I will now turn to persons who wish to testify neither for nor against LD 1950 to please raise your electronic hand. And I will begin with Julie Finn, followed by Frank Bishop. If the clerk could move both over as panelists, that would be greatly appreciated. Good afternoon, Ms. Finn. Nice to see you again. And I hope you noticed that you are not being called last today in the line of testimony. Thank you very much for being here. Please begin your testimony when you're comfortable.
Thank you for that, Representative Harnett. And I also promise, even though I'm not being timed, that I will not take 3 minutes. Representative Harnett, Senator Carney, members of the Joint Standing Committee on Judiciary. My name is Julie Finn, and I represent the judicial branch. I would like to provide some brief testimony this afternoon, neither for nor against this bill. As you know, the commission to study this was comprised of, well, Chair Senator Carney and Representative Cardone, 3 other members of this committee, Senator Keim, Representative Hagan, and Representative Sheehan, several probate court judges, a register of probate, members of the public, Leo Delicata, who testified earlier on behalf of Legal Services for the Elderly, and 4 members from the judicial branch. And those were Associate Justice of the Supreme Judicial Court, Ellen Gorman, District Court Judge John Martin, Catherine Wiltuck, who's Director of Court Process, and York County Clerk Julie Howard. So in other words, all the right people were at the table to discuss this important matter. Numerous documents and countless hours were spent reviewing and discussing this proposal. Consensus was reached on many difficult issues, resulting in the LD that is presented today. The judicial branch takes no position on the ultimate issue, that is whether the probate courts should be incorporated into the judicial branch. That is a question for the policymakers to decide. However, appropriate funding is critical for the recommendations to be successfully implemented. To this end, judicial branch personnel, including all of the members who are on the commission, as well as staff from our finance department and court operations, which oversees the clerk's offices, have been meeting over the last couple of weeks and are working on the fiscal analysis for this bill. It is quite complicated given the scope of the proposed changes, as you might imagine. We are working to complete that analysis as quickly as possible. And thank you very much for your consideration, and I would be happy to answer your questions if I can.
Thank you very much, Ms. Finn, and thank you for being here and providing information to the committee today. Are there questions from committee members for Julie Finn? If so, please raise your electronic hand. And I am not seeing any, and I will point out, Julie, that indeed you did come in at under 3 minutes, as you always do. You have so much time in the bank if you ever want to ramble on some issue in the future.
Thank you.
Thank you very much for being here.
I'll remember that.
And I would next call upon Frank Bishop. Welcome back to the Judiciary Committee, sir. When you are ready, please begin your testimony.
Senator Carney, Representative Harnett, and members of the Judiciary Committee, my name is Frank Bishop. I'm the president of the Maine State Bar Association, and I'm here to speak on behalf of the Bar Association today. We're not taking a position on this bill, so we're neither for nor against LD 1950 in circumstances in which there's maybe not entirely consensus within the Maine State Bar Association. We don't take a position on the bill. But what we did in this case is we sent out a survey to our 3,000 members that included the recommendations of the commission, the final report of the commission, and we identified what we thought were the 4 key recommendations of that committee and asked whether people strongly were in favor, just in favor, strongly opposed, opposed, or undecided on each one of the 4 key recommendations. As part of our testimony, I've given you the results of that survey. I don't know if the analysts can call those up, but you can take a look at them. Either way, I'm going to briefly summarize them. So we had 195 people respond to the survey, and 147 of those 195 identified themselves as practitioners within the probate court system. And I would say, characterizing the results, that there's broad consensus, there's broad support in favor of the commission's proposal on each one of the 4 recommendations. So before I get to the exact survey results, we did include an open-end kind of comment section in the survey to try to solicit what people thought were key issues for you to consider. And I have 5 of them. 1, the need for one uniform probate court system across the state instead of a system with county by county differences. 2, a preference for appointed judges versus elected judges. 3, a desire for probate judgeships to be full-time positions and to not allow probate judges to practice law in addition to serving as a judge. 4, a recognition that current registrars and their staff have institutional knowledge that will be important to maintain during the transition. And 5, a concern about the current backlog in the judicial branch impacting the ability of the judiciary to take on probate as a 3rd branch. So nothing surprising there. It's everything you've heard earlier today. If you turn to the actual results, you'll see that we broke them down by probate practitioner and non-probate practitioner, and then combined those into a total on each one of the 4 issues. And if you look carefully at the results, you'll see that there are differences between probate practitioners and non-probate practitioners that might be interesting to you to think about as you consider the bill. Broadly, the county probate court system should be fully incorporated into the state judicial branch through a multi-step process over the next 5 years, subject to review. Strongly and agree, 68.7%. Disagree, strongly disagree, 25.1%. As part of the phased-in process to move the probate court system into the judicial branch, phase 1 of the transition should include replacing Maine's elected part-time probate judges with 9 full-time appointed judges within a separate branch of the judicial branch. 70.7 strongly agree or agree. 23.1% disagree, strongly disagree. As part of the phased-in process to move the probate court system into the judicial branch, phase 1 of the transition should retain Maine's current system of elected county registrars of probate along with their office staff. 64.6% strongly agree or agree. 21.6% disagree or strongly disagree. And finally, responsibility for establishing the qualification of court-appointed attorneys, guardians ad litem, and visitors in probate proceedings, and for paying these professionals when they are appointed at public expense should be borne by the state and not county governments. 79% strongly agree or agree. 6.7% disagree or strongly disagree. So we're hopeful that this information is helpful as you consider this bill. I'm happy to answer any questions. And if there are things you would like us to follow up with our members, I'm happy to put together that kind of survey.
Thank you very much, Mr. Bishop. And I apologize if you gave, I know you're representing the Maine State Bar Association. Did you give your town of residence? I apologize if you did.
I didn't. So I live in South Portland, Maine, in Cumberland County.
Thank you very much. And committee members, I know that we have the chart, the statistics from which Mr. Bishop was quoting that you could review. Are there committee members that would like that shared by the analyst to see those numbers right now? If so, just raise your hand. Otherwise, I would encourage you to review it before we get to the work session. And I am not seeing hands. So at this point, I will ask if there are any questions for Frank Bishop from committee members. If so, please raise your electronic hand. And Senator Carney.
Yeah, I know that I am the legislator who introduced this bill today, but I did have one question for Mr. Bishop. Is it okay if I proceed?
Given that I asked you to introduce the bill, it is absolutely okay for you to proceed, Senator Carney.
Thank you. Mr. Bishop, I was struck by the 79% approval rate for having the judicial branch responsible for the quality of court-appointed counsel and also shifting the pay from the county for those appointed counsel from the state, from the counties to the state. And I'm just curious as to whether you received any specific comments on that point, because that kind of jumps out from the other spreads on agree to versus disagreeing.
I don't have specific comments on that. And that's a question I'd be happy to put back to our members if you're interested. But I would suspect that in general, if you asked a group of attorneys about whether they think costs should be borne by the county or the state, that they're going to say that they should be borne by the state. But again, that's just that's an assumption I'm making that's not based on any data.
Thank you, Senator Carney, and thank you for the response, Mr. Bishop. Are there additional questions from committee members for Frank Bishop? Seeing none, again, thank you for your time this afternoon, and we appreciate your input and very much appreciate the survey responses from your members. Thank you. I will turn back to the attendee room to see if there are any other persons who wish to be heard at all on LD 1950. We are right now at neither for nor against, but if there's anybody that I missed, please raise your hand. And I am not seeing any. So with that, I will close the public hearing on LD 1950, but I want to ask committee members again, and to remind you, this is a weighty, in more ways than one, piece of legislation. It's 46 pages. And I would ask if there is any specific information you would like brought back to an upcoming work session. If you have any ideas in that regard, if you could please raise your electronic hand so we can communicate that to our analyst. Representative Evangelos.
I believe I heard Ms. Finn say that they're developing a dossier on the potential impacts. So that's why I didn't repeat my question. She answered it in her testimony. But yeah, that would be one thing I want to know.
So the impacts on the civil and criminal document?
Just the impacts on this court, the entire court system, whether it's going to have any impact on the on any of the other day-to-day operations. I think Ms. Willis said no. It looks like it's going to be a tightly knit thing. But anyways, yeah, I just wanted to know what Julie and the judicial branch has to deal with to make this happen on their end.
Okay. Ms. Finnis is still in the attendee room and has heard that. And I believe in her testimony, she mentioned that they were working on crunching some of the dollar numbers at least. So
yeah, that's what I was getting at also. Thank you.
We will have that information. Are there other committee members that have specific information they would like to have brought back for an upcoming work session? And I am not seeing any. So I want to thank you all for your attention this afternoon. Special thanks to my co-chair, Senator Carney. And I will now turn to our two analysts and our committee clerk to see if they have anything. I'm sorry, Representative Thorne.
Yes, well, this had to do with the memo that was sent out. So if you wanted to take care of any other business, I just wanted to make a comment regarding the memo.
Okay, I'm not sure that we were going to, we might set aside a particular time to talk about that. I'm not sure if everyone has had a chance to review it. So I would probably give that a day or till we're back together next time. But I will, I do see two other hands up. I see Senator Keim and Senator Carney.
I'm guessing we have our hands about the same.
I'm sorry, Senator Carney.
I think we probably wanted to raise the same thing. I think we have a bill to reconsider, a vote to reconsider.
We do. Thank you very much. I forgot that. That was, is it Eldine? I know it was Senator Keim. So if you could address the bill that you wanted to reconsider.
Yes, it was Senator Diamond's bill, LD 1857.
And do you want Peggy to go over the posture that sits in, or do you want to address?
I think for committee members, it might be good for her to just recap that so they understand, because then we're all going to have to revote this.
Okay, thank you. Peggy, is that something you could do for us, please?
I would be happy to, and I will have to turn to Soupy for the actual vote count on it. But what I'm going to do is share the screen of what the amendment looks like. So I believe this was the minority report for 1857 about prioritizing child murders. The Attorney General prioritized child murders. The vote was to strike out Section 1, which is a statutory direction, and include just Section 2, which requires the Attorney General to send a formal request to the judicial branch in scheduling to homicide cases in which the victim is a person who has not attained 18 years of age. That was a minority report. And then in a completely separate vote, there was a letter that I believe the majority of the committee supported to Attorney Generals, the Attorney General and state police acknowledging their work on investigations and prosecutions. I haven't written it yet, but yeah, that was a separate vote. This, I believe, is the minority report. And I believe Senator Keim is on the majority ought not to pass report. And again, Soupy will have to confirm that because she's been collecting votes.
I will wait for Soupy to confirm that.
And if you'd like, I'm gonna stop sharing, but I'll pop it back up whenever you need it.
I can confirm the vote for you was, the final vote was 8-6. 8 voted ought not to pass. 6 voted ought to pass as amended. And Senator Keim was on the majority ought not to pass.
Okay, and Senator Keim, I note you would like to have a corner caucus. Is that before you explain what you want? You want to talk to your caucus before coming back to us?
Either way, I just also feel like I should tell the committee why I want to change my vote.
Okay.
Just I had a further conversation with Senator Diamond, and he, I feel like in deference, honestly, to his longstanding commitment to this issue and work that since he believes that this sends the message that I definitely agree with and want sent, which is that we want greater oversight, that I want to vote in favor of this bill and make sure that as it leaves our committee, that it does so with my name voting in favor of the minority position. The minority ought to pass as amended.
Okay. So, and you want to address, do you want to make that motion or do you want to address your caucus before?
I can make the motion and then we can do a short corner caucus. Yeah, so I would make a motion ought to pass as amended.
Mr. Chair?
I'm sorry, yes, Representative Babbage?
Thank you. I think we have to have a motion to reconsider.
Thank you. I was about
And
to
vote on that.
Thank you. Point that out. Thank you, Representative Babbage. I believe you want a motion to reconsider?
Yes, I make a motion to reconsider LD 1857.
Thank you. And do we have a second? Seconded by Representative Babbage. And at this point, we will break for, so you can have a corner caucus. I'm sorry, Representative Babbage.
I think in some way you need to take the poll either by hands or informally or formally, but.
Take the vote on the motion to reconsider?
I think the committee has to give its consent to reconsider.
Okay, then why don't I ask the committee clerk to call the roll? Thank you. And it's on the motion to reconsider by Senator Keim, seconded by Representative Babbage.
Thank you, Mr. Chair. Representative Galgay-Reckett. Representative Newell. Representative Evangelos.
You're muted, Jeffrey, Representative Evangelos.
I'm sorry. I'm voting yes. It's a courtesy we should extend to each other.
Representative Evangelos votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Sheehan. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. I'll recall the absentees. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Newell. Representative Newell is absent. Representative Sheehan. Representative Sheehan is absent. Representative Hagan. Representative Hagan is absent. Mr. Chair, I have 10 members voting in the affirmative, 0 in the negative, and 4 members are absent.
Thank
That is the
you.
vote of the committee.
Thank you, Soupy. And Senator Keim, how long would you like for your caucus?
Thank you. Really just 5 minutes.
Okay, we will reconvene at, I'm sorry, Representative Babbage.
May I ask of Senator Keim if the amendment, the minority report is actually changing as a result of the reconsideration request?
No,
Not in
I was-
number, but in, yeah,
Right. Yeah, I was just going to vote with the minority.
thank you.
Yeah,
Thank you.
thanks.
Thank you. We will reconvene at 1, I'm sorry, Senator Carney.
I just wanted to let our caucus know that we will also be having a corner caucus.
Thank you very much. We will reconvene at as close to 1:20 as we can. We have some Zoom movement to go around. So it may take a couple of more minutes, but thank you very much. See you all in a couple minutes. We stand in recess.
I don't see Representative Harnett, so I'm wondering if he had to sign off and sign back in.
I think he'll be here in a moment.
Okay.
Peggy, if I may, last time we probably had a motion of ought not to pass. This time we're likely to have a motion of ought to pass as amended. A small difference, but it was a negative action last time, if I recall. And this time we're going to ask Senator Keim to make an affirmative action.
Okay, once you've voted to reconsider and that passed, then
It's free game.
empty. It's a
new
tabula
bogey.
rasa.
Well, then I'm going to, as chair, ask, as she made a motion to reconsider, to Senator Keim, do you have a motion?
Yes, I make a motion ought to pass as amended with the amendment that we had previously.
Thank you. We have a motion from Senator Keim. Do we have a second? Seconded by Senator Carney. Is there any discussion?
I would like to, may I?
Yes,
Mr.
you
Chair?
may. Representative Babbage, I apologize for not being quick on.
No, I didn't get to the electronic. I apologize. Usually it's there waiting for you, but I just wanted to explain that I had a small interchange with the senator following our vote too, and he was appreciative of our discussion last time. And that although I will stick with my original position, I do so only because the courts expressed to us that a primary consideration on what should be on the docket first would usually be how long has a defendant been waiting in jail. That seemed reasonable to me. And I also was a little sensitive to the legislative branch directing a separate branch on how to do their business. I totally understand the messaging here, but I was satisfied with the letter, and I just wanted to explain my thinking in going forward with the vote. So thank you for that, Mr. Chair. Appreciate it.
Thank you, Representative Babbage. Any further discussion? If so, please raise your electronic or human hand. I think I can see them all today. Representative Thorne.
Thank you, Mr. Chair. And Representative Babbage actually brought up a point that I thought I had heard someone mention, is that by virtue of it going through the Attorney General, it's not connected to judiciary. Is that correct? It's once removed in a way? And that's to anyone that could answer the question.
So I think your question is this as big a separation of powers question when with the legislature directing the judicial branch had to do things?
Right, by having the bill addressing that the Attorney General,
right,
that doesn't involve the judiciary branch or the legislative branch directing the judicial branch per se, because the Attorney General is removed and doesn't fall under the judiciary branch. Am I correct in that, Diane?
You're definitely correct that the Attorney General does not fall under the judicial branch.
Yes.
And I think I would agree that it's the legislature directing the Attorney General to request something of the judicial branch does not raise those same separation of powers questions.
Normally, who does direct the Attorney General in their duties?
Oh, I think the legislature has a whole lot of power to direct the Attorney General. And so I don't think that's a question. I think that a question is often raised when there's a law or something else that is trying to tell the judicial branch how to carry out its responsibilities.
So we are acting within our purview to do this if we chose to pass it?
I think that you're acting within your powers to direct the Attorney General. The judicial branch may refuse to do what the Attorney General requests, but I don't think there's a separation of powers question involved in what's left in this bill.
But then it's up to whether or not the judicial branch chooses to follow the advice of the Attorney General, correct?
I think that's always the case.
Okay.
I
Thank
see we have quite a few hands up. Representative Babbage, is that a latent hand?
No, it actually isn't.
Yeah, I'll get back to you.
Okay,
then.
great,
We
great,
have
thank
other
you.
hands up. I'm going to go to Senator Carney.
Thank you, Chair Harnett. I just wanted to clarify that in Senator Kimes' ought to pass as amended motion, that section 1 of this legislation that pertains to the Attorney General has been taken out of the bill, and that's the amendment. Is that correct, Senator Keim? Or Peggy?
Section 1 has been taken out of the bill, but yes, maybe Peggy, you would screen share one more time.
That would be helpful. Thank you.
Right, so there's still, section 2 is the Attorney General shall send a formal request to the judicial branch to give priority in scheduling to homicide cases in which the victim is a person who has not attained 18 years of age. So that's a formal request. That's not directing, it's not the Attorney General saying you have to do this, but it is a request to take that into account. And yes, you do have authority to tell the Attorney General what to do. Although the Attorney General does have some prosecutorial discretion, but I think this is something that the Attorney General can be directed to do.
But it does not bind the judiciary in any way. It's simply
Not in any way.
Simply a request. Thank you. Do people still need the screen share? Did that clear up your question, Senator Carney? Thank you.
Thank you.
Representative Moriarty.
Thank you, Mr. Chair. I still have a concern as to whether or not we are improperly directing the executive branch to do something. I see the Attorney General's department as being a branch of the executive
Isn't though.
branch. Secondly, what we're doing is sort of using the Attorney General as a conduit. We're trying to get through the back door that which we can't get through the front door. And so I just don't like that technique, and I'll be voting as I originally did.
Thank you. And if I could just ask Peggy a question to see if my memory is correct. I believe that when the issue was raised, the Office of the Attorney General is not in the executive branch. It is a constitutional office. Is that correct?
Correct. It's kind of a separate entity. Yes, they execute the laws. So functionally, they're part of the executive branch, but constitutionally, they are independent of the executive, independent of the governor.
Thank you. Representative Evangelos.
Thank you, Mr. Chair. Peggy, I just want to make sure what I'm voting on. So we are reconsidering what we voted on last time. There is no new amendment, right?
Right. You didn't have this in front of you. What you had in front of you was sections 1 and 2 of the bill. And this is just the quick markup of the bill of what the amendment, the minority ought to pass as amendment report was. My understanding is you're not changing that. You're just changing votes.
Thank you.
Are there additional questions from committee members before we proceed to a vote?
I would like to just comment, if I may, Mr. Chair.
Go ahead, Representative Babbage.
I think the amendment gets to a very good place and an appropriate one, I guess, as far as the legality of, I perhaps shouldn't have mentioned separation of powers, but I am getting to that. And I use the right word. I didn't say it was a violation. I said I'm sensitive to the separation of powers issue here, in that we are making a request through a constitutional officer, which has some clout, in my opinion, to interrupt your application of justice to follow what we believe to be a preferred application of justice. And I do not have a problem with their priorities as they're presently administered, and the fact that they said that they do put this as a very high priority. The only time they may not follow through on this would be if in fact somebody's been sitting in jail for an inordinate amount of time that deserves to have their case heard. So I just wanted to point out, I'm sensitive to separation of powers, but I did not mean to say that we were doing anything inappropriate. I just think it's unwise. So thank you.
Thank you, Representative. Are there additional questions before the committee proceeds to a vote? Additional discussion? Seeing none, I would ask the clerk to call the roll.
Thank you, Mr. Chair. Representative Galgay-Reckett. Representative Newell. Representative Evangelos.
No.
Representative Evangelos votes no. Representative Poirier.
No.
Representative Poirier votes no. Senator Kime.
Yes.
Senator Kime votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Oh, I'm sorry. No.
Representative Babbage votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Sheehan. Representative Moriarty.
No.
Representative Moriarty votes no. Representative Hagan. Representative Libby.
No.
Representative Libby votes no. I will recall the absentees. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Newell. Representative Newell is absent. Representative Sheehan. Representative Sheehan is absent. Representative Hagan. Representative Hagan is absent. Mr. Chair, I have 4 members voting in the affirmative, 6 members voting in the negative, and 4 members are absent. That is the vote of the committee.
Thank you very much, Soupy. And could you just remind me, I know you tell us all the time, how long members have to get their vote, indicate their vote to you? Those that are absent?
It is noontime on the second day.
Second business day.
Second business day. And since you're in session tomorrow, I will not be sending the email. I will actually physically be going after you for your vote.
You will seek people out.
I will. But before we even do that, though, I do, if I could, have a report from the noes. It's a divided report, so I
That
need,
ought not to pass?
is that the,
In my case, yes.
Yes.
Okay.
I agree.
Thank you.
very much.
Thank you.
And
Senator,
actually, sorry.
I'm sorry, I just saw Senator Kime's hand up.
I would just like a minute to address the committee before we sign off today, whenever that's convenient.
Okay, why don't I just see if the one, if I forgot anything I'm supposed to do, like that motion to reconsider, and if Peggy or Soupy have something they need to tell us. So Peggy, you were starting to talk.
I was just going to say, I know that Soupy's going to be coming around to catch the absentees on this bill, but she also has a divided report that she's going to need your confirmation on the vote. 1818. Are you done with that?
You're muted.
Thank you. I will actually get signatures for that one. I won't need approval.
So that means she's going to be seeking you out tomorrow for signature.
I will be, like a heat-seeking missile.
Okay. Thank you. I'm done.
Thank you.
Thank you very much. Did you have anything else, Soupy, for the committee?
I do not at the moment. Thank you, Mr.
Thank
Chair.
you. And then Senator Kime, now's your opportunity to address the committee.
Thank you. We wanted to raise what I find to be concerning in our process. And like this morning's bill, LD 1310, sort of exemplifies that, you know, we have a hearing, we don't have language on it until yesterday at 1, and we are expecting people to be able to participate meaningfully in the process, and yet we're not giving them time to do so. And the same happened last week when we had a constitutional amendment which rises to an even higher level than just regular bills. And yet we get language very late, and then it didn't even allow any opponents to speak, or really even time for them to process. And that's a constitutional amendment. And I'm a great deal concerned that we still do not have language for the tribal land claims bill that we're hearing next week on Tuesday. And so there's going to be completely new language coming to us. And from what I have heard from the governor's office, we probably won't be getting that until Friday, maybe. And yet we're supposed to have a public hearing on Tuesday. And with that bill, there's no going back, right? I mean, that's an agreement that gets made between two sovereigns, essentially. And that unless both agree, we can never go backwards on that. And yet we've given the tribes, they've had months of discussions with the governor's office to come up with this bill that they probably approve of. I guess that we'll wait to see, but yet the Maine people haven't even seen it. And we're giving them a weekend and a business day to come up with a response for something that could be very far reaching and is basically binding them in perpetuity. So I have grave concerns that we are moving forward with this bill when we do not have language. I think it's a slap in the face to the people of Maine, and it's an improper way for us to be conducting our business. And I wanted to bring that up today because next Tuesday, it's the day. And I think it's improperly before the people of Maine at this point. It's too far reaching and too significant for us to expect folks to come up with a meaningful response that we need to hear without giving them time to digest it. So that it continues to be a problem, I understand, of short session, but some issues rise at too high of a level for us to be pushing them through, and this bill is definitely one of them.
Thank you, Senator Keim. And I just want to address next Tuesday and invite my Senate co-chair to correct me if I am wrong. Next Tuesday, we are hearing LD 1626. And that's the only bill we're hearing that day. And I believe we have all the language, that we've had the language in that bill for quite a while. Am I incorrect, Senator Carney?
I haven't heard anything about an amendment to 1626.
But we, I hear your concern, and I hear your concern regarding the constitutional amendment that we listened to the other day, and we will address that concern. Senator Carney, you have your hand up.
Yeah, I did want to address the issue with I think it was 1529, the right to privacy. And you sent me a really thoughtful email, Senator Keim, and I agree with you. And that's why I think if you watch the tape from that work session, you'll see that once it became apparent that the sponsor, the people the sponsor had brought to the hearing, who I thought were going to kind of catch us up to where we had been last spring, were kind of going into a pretty extensive description of a very broad issue regarding right to privacy. I stopped that portion of the work session and pivoted to asking committee members what we as a committee needed to vote on that legislation. And then we came up with a list of requests for information. And I know that Peggy and some others from OPLA are actually working on getting that information. I actually agreed with you that that wasn't the right forum for that. I did also want to note that the amendment that was on the table at that work session was actually an amendment that the bill sponsor had given to us at the initial public hearing on that bill. And I think it was May of 2021. So there wasn't new language there. I do apologize for the late arrival of the language for 1310. That sometimes things like that happen. And all I can say is I apologize that people didn't have it sooner. It was not something that I could control, but your objection and concern is noted. And then I also did want to point out that there have been negotiations regarding other issues related to the relationship between the tribal nations and the state of Maine. And we will see an amendment on LD 585, I believe, on Thursday. We are trying to get that information out to the committee and to members of the public. The concern, that work was hampered a little bit by a lot of different factors, including some unavailability of people due to family emergencies. And we have been working to get that out. And if we feel that we need more time, or we need to table the public hearing and resume it at a later date, I'm very open to that, because I agree with you that these are really important issues for all of the stakeholders, for everyone in Maine, as well as for the tribal nations. And I think that we're going to make sure that people have the time they need to consider the legislation. And I appreciate you raising the issue. And to the extent that you think of anything that and I'm going to speak on Co-Chair Harnet's behalf, if there are things that you think that we can do differently and better, please let us know.
Thank you, Senator Carney. Representative Moriarty.
Thank you, Mr. Chair. I agree with Senator Keim on 1626. If in fact there's going to be a new bill between today and Tuesday, or an amended bill, that's just too short a time. But I understand the co-chairs to say that there is not going to be an amended bill. So if that's the case, I'm okay in going forward. On 1310 this morning, I felt badly for you, Mr. Chair, because not only did we all get the language late yesterday, but you had to fill in for a sponsor who could not be present, undoubtedly because of valid concerns. But with the combination of late filed language and an inability of a sponsor to attend, my thinking is that something like that ought to be postponed.
Thank you, Representative Moriarty. Senator Keim, and then Representative Evangelos.
Thank you. I just so that I understand correctly, so that is different than what I thought I understood from the governor's office. And I thought from my conversation with them that they had said the amendments that they had been working on with the tribes would be a replacement for 1626. So Senator Carney, is that not your understanding?
I have a different understanding, as I indicated earlier, but maybe we should both double check and figure it out, because obviously we're getting different perspectives. So I think it's good for us to straighten it out. Thank you.
Okay,
and I'm committed to double check that as well, Senator Keim. That is not my understanding about what we're going to see on Tuesday. Representative Evangelos, and then Senator Sanborn.
Thank you, Mr. Chair. Very briefly, there's nothing out there on any amendments that I can see. And we did get the language for LD 1626 on April 27th, 2021. I see no other language out there. And I just want to remind the committee that it's the prerogative of the legislative branch to bring legislation forward. The bill has a sponsor, and that's our rules. It's in the sponsor's hands. I'm not aware of another branch of government having a role in that.
Thank you, Representative. Senator Sanborn.
I just want to reflect on this from my perspective as having served on 3 other committees of the legislature in my 6 years of service for the state of Maine, and to say that amendments arise from a variety of sources and suggestions before public hearings, after public hearings, during public hearings, weeks in advance, moments in advance, at work sessions, at the collaborative, creative, innovative minds of the legislators or of the experts that we're talking with. I've seen it happen in all of those ways. And we certainly have the ability as a committee to have a number of sequential work sessions in order to continue to work through those issues. And it is the discretion of the chair, whoever the chair is who's presiding, to invite additional voices from the public to give additional information at those subsequent work sessions as well. So just trying to bring some perspective from outside the Judiciary Committee. Lawmaking is messy, and the process by which lawmaking is done, particularly by this group of part-time, non-professional citizen legislators, is not always going to have weeks and weeks of notice. In fact, our presiding officers are suspending the 2-week notice and reducing it to 1-week notice because we have a reality about how we have to get our work done. So I just want to make sure we're putting this in the proper context, which is to say it would be wonderful if we had lots and lots and lots of time to consider any kind of language changes that might be different from the printed bill. But the reality is that's often not possible, and that canceling a public hearing silences voices, and postponing a public hearing is not something that our presiding officers generally will approve of. So just want to add that additional perspective to this conversation.
Thank you, Senator. Senator Carney?
And I also just wanted to note that we actually are not supposed to cancel public hearings. And if this morning, for example, if there was a concern that the public did not have enough time to consider LD 1310, I wish that one of us who had that concern would have suggested tabling the public hearing and resuming it at a later date. I just want to remind all of us that is an option that we as a group can consider if we feel that it's important in order to do the best work that we collectively do on legislation. Thank you.
Representative Moriarty.
Thank you, Mr. Chair. I just want to respond a little bit. At this time yesterday afternoon, with respect to 1310, I think all we had was a concept draft, and the language came in later. And I didn't know until the hearing was formally opened by Chair Harnett that the sponsor was not going to be present to answer questions. If I'd known that somehow before the hearing got started, I might very well have asked for a postponement, but we were technically into it. We crossed the starting line and then learned that there was really nobody present to answer questions about the bill itself. So awkward situation. I don't mean to be critical, but it's something I think we'd like to avoid if we can.
Thank you, Representative. I see somewhere it says there's a hand up. Senator Carney, is that still yours? Go ahead.
Yeah, just again, rather than a postponement, I think the appropriate step would be a motion to table, and that's something we could do. And I just want to assure you, Representative Moriarty, that there was a pretty significant emergency that required the bill sponsor to not be present this morning. And I know that she will be present for the work session so that you can ask your questions at that time.
Yeah.
Representative Moriarty, did you?
I just want to say I'm not questioning the situation of the sponsor whatsoever. It's just that the point was made that once we'd advertised a public hearing, we really should never cancel it. if these emergency situations arise, both with regard to the distribution of the text and the ability of the sponsor to be present, then a tabling is appropriate.
And I would just point out in response to that, in response to a lot that has been said, the purpose of the public hearing to a large degree is to allow the public to testify on a bill, putting aside the timeliness of receiving the actual language of the bill. And the time for working the bill is a work session. And if you have the public there, we need to allow the public to participate and then table if necessary. But I don't want to shut people down who are there for a particular hearing. But it was an unusual circumstance, and we handled it the best we can given the amount of time that we had to deal with it. Senator Sanborn?
Yeah, I just want to reiterate that the senators who are chairs received explicit instruction that from our presiding officer, that public hearings are not to be postponed after they have been advertised to the public in the interest of ensuring that the public who is present to testify is given that opportunity. And the public notice and the interested parties list as to exactly what the draft of the bill is, was updated yesterday, almost 24 hours prior to the hearing. So I think it's really important that the committee members understand the message that we are receiving from the presiding officers is that all public hearings will be held when they are scheduled.
Thank you, Senator. Are there any other persons that would like to be heard on this or other matters before we adjourn for the day? Representative Thorne.
Thank you, Mr. Chair. I did want to mention briefly today the memo, even though not everybody's here and maybe not everybody's read it, but the important reiterations of showing respect at all times and not being disruptive and argumentative and oppressive, repetitive, or unnecessarily embarrassing. Those are good reminders, and I can only imagine what's going on in some of the other committees, and I'm glad that you and Chair Carney are running Judicial Committee in a smooth and timely manner, and we have none of these issues.
Thank you.
Thank you for that.
Thank you, Representative Thorne. And as I said earlier when you raised this, we will have a time to discuss this as a committee, even if it's just an important reminder. But remote meetings present a lot of challenges, and decorum is one of those challenges. So I think it's important for all folks to read the letter, digest the letter, and when we next get together, we can discuss it as a group. Okay. Is there anything else before I would entertain a motion to adjourn? I see another hand up, Senator Carney.
We will next be together next Tuesday for the public hearing on LD
1626.
And I would ask if committee members can be a little patient and discuss that memo, perhaps on a day that is not going to be quite so busy for us. I'm just aware of the time that public hearing is likely to take, and that the public will be waiting. And I would prefer that we not have that extensive discussion while all those folks are waiting, out of respect for them.
Okay, thank you. Representative Thorne, is your hand up anew?
Yes, it is. Thank you, Mr. Chair. I had nothing great to discuss about the memo. I just wanted to mention that I received it and let everybody know that I'm glad we have a Judiciary Committee that runs like a well-oiled machine and don't have any of these issues.
Thank you. Appreciate that. And I'm not even sure I want to ask again. If I think I'll just entertain a motion to adjourn. How does that sound? Do I have a motion to adjourn? Moved, seconded by many. Thank you very much. We look forward to seeing many of you in person tomorrow. Thank you to all of you today. Thank you to our staff, both analysts, Supi, Peggy, and Janet. And travel safely coming to Augusta. Take care.
Okay. Thank you then.
Hey,
See you
Chris,
tomorrow.
Good night.
Be well.
Chris, do we have to call Representative Moriarty, Your Honor?
Yeah.
Isn't that taking this a little too far?
Somebody else got promoted today too.
I'll leave that up to you guys. Thank you.